So we are here again, and they have not put. Wait, today is day 5? No, today is. Let me check this. Having a brain fart. Today is day 5. I feel like we've seen all this. Yes, we have. My brain is not here today. This is awesome. Hello. We are waiting for them to put up the actual current day stuff. So Fry and my co-host and I, as he is busy, one of my children has unboxed one of my hilariously inappropriate children's mushrooms toys. So it has become a Fry toy. So I have some other newsy news that we can get into. Yeah, it's so crazy. Everyone has a trial, which is awesome, which means everyone is getting, stuff going. Baker and Jamie have stuff going. It is awesome. So everyone has people that they can do and things they can do. So that is just, I mean, I am glad that everyone has things to do because last week was kind of hard when we didn't have anything that was going on because it was nice because I kind of got this going. Oh, okay, well, we can definitely. I didn't realize Karen Reed had a something going, but we can definitely go to a Karen Reed. I can do a Karen Reed. Oh, ta-da. No, I don't. What are you doing, stinky face? 1 second here.
Represented by the Commonwealth during its numerous bail arguments regarding this matter have been shown to be false. It is a fact that the nature and circumstances of this case have completely
Oh,
changed,
for the love of
even since
Cheetos.
the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor.
All right, let me try this again since it's being a pain in my buttocks as per usual.
By the time I got back to my office that afternoon, I
All
had
right, can
already
you hear
begun
it
to
now?
learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime. But shockingly, at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie.
Good idea.
Rather than take Michael Proctor's word, we instead sent our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street. Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th. And when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there. And Mr. Laughlin was firm with Trooper Proctor. There was no body. And he told him not only was there no body, but if there had been a body there, he would have seen it. He left Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case.
Wow.
To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting
Oh my gosh,
her.
the blonde woman
No
back
body at
here,
2:30 a.m.
her mouth
She
is
innocent.
open like,
But Your Honor, it's not
crap is
just that
going
he
on.
saw no body at 2:30 a.m. After
Where's
that, he
Turtle
saw
Man?
Ford Edge parked right in the area where John O'Keefe's body was later found. Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons know or knows exactly what happened to John O'Keefe. That
Oh, okay.
mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe, and that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail. Frankly, when the Commonwealth relies on the nature and circumstances of the case in order to justify bail being set, those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in part on a representation by Mr. Lally at my client's arraignment that there was that apparent hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed her proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer
oh, for the
McCabe,
love of all that is
who had been at Brian Albert's
spam.
house on the night in question,
This is
and
not
would
even
have had to
ham, it's
walk by
spam. And I
John
love
O'Keefe's
spam,
body
but
in
for
the
the love
yard
of
if it
spam and
actually
eggs.
was there at that time, went home and at 2:27 a.m. Googled Hosslong to die in cold. You did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert not only found that search, but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert is certain. And importantly, the Commonwealth's handpicked expert, Ms. Hyde, confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it goes without saying, Your Honor, that Jennifer McCabe's Google search, trying to determine just how much time had to pass before John O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that a human hair was found in my client's car when it wasn't, But importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and reveal that Chloe attacked not just one, but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his conscience.
Just 1 second, because look, Fry, I think, is a miniature, German Shepherd slash mutt shepherd, but him biting me, just puppy stage, my arm looks like kinda mincemeat. I mean, you can't tell, but, puppy teeth hurt. That was a great big German Shepherd. I mean, those wounds look like bite wounds to me. I'm just like, I'm not a criminologist, but those wounds look very similar to what my arm would look like if Fry were a full-on grown ass German Shepherd.
Consciousness of guilt. You should have been able to consider that before you set bail in this case, but that information was kept from you. It is now yet another changed circumstance that justifies the lowering of Ms. Reed's bail. Now, I expect that the Commonwealth will argue 2 points in opposing this motion, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and two, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle. He was in the vehicle that night, shortly before he was killed. He was around the outside of the vehicle several times that day and night. That vehicle was parked at his house for months. He lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m., a Ford Edge being near the yard where the body was later found after 2:30 a.m. Jennifer McCabe Googling how long to die in cold at 2:27 a.m. And then 3 minutes later, Brian Lawfern driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail argument? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the
So
appropriate time.
I don't need to see a chalk, Mr. Yannetti. You didn't give me sufficient evidence under Commonwealth versus Brangan.
Well,
So I will hear you because you want to make this statement. So go ahead, but no chalks.
You're right. Just so we're clear, it's not just her financial status that justifies reducing the bail. The thrust of my argument is all with regard to changed circumstances.
I understand that, so I'm going to let you continue. But a very important piece of this is missing. So go ahead with your argument. No chalks, please.
Yeah. And obviously my argument is, leaving the financial issues aside,
I have no idea. I'm not a lawyerologist, so I don't know what chalks are.
I had just stated, Your Honor,
But I
that
will find out.
in order for that, the microscopic supposed pieces of taillight to have any evidentiary value, you have to trust who had custody of them, which means that you have to trust Michael Proctor. And I question, how on earth can anyone trust Michael Proctor? I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by seeking the case. The more appropriate word to describe him is corrupt. Only a corrupt state trooper would agree to investigate a murder case in which a body was found in the yard of a family friend. Only a corrupt state trooper would keep his ties to that family friend hidden. Only a corrupt state trooper would refuse to go inside the home, which featured the body of a dead police officer on its lawn. Only a corrupt state trooper would write in his report that a street had not been plowed when it had. It was the corrupt Michael Proctor who took custody of John O'Keefe's clothing, and that clothing was not submitted to the lab until several weeks after Michael Proctor seized it. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet, you see a pile of John O'Keefe's clothing, unattended, sloppily thrown on the floor. That's the care with which Michael Proctor treated what they now claim is important evidence. And that clothing was not submitted to the lab, Your Honor, until after Michael Proctor had seized my client's Lexus, and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of not sending it to the lab until March of 2022. He had it for weeks. Michael Proctor's mother has described the Albert family as the Proctor's second family. Michael Proctor told witnesses who showed up to testify before the grand jury that Brian Albert is the salt of the earth. Michael Proctor's wife has posted about how much they love Colin Albert. The Proctors have constantly been photographed with the Alberts going back over a decade. We've shown that Michael Proctor's in a wedding party with Colin Albert. Colin Albert was the ring bearer at Michael Proctor's sister's wedding. It's so clear that Michael Proctor was both conflicted and corrupt. He had every reason to sprinkle tiny pieces of taillight that he had seized into the clothing that he alone took, so that the lab would later find it weeks later, and sure enough, they did. And this supposed discovery does not undercut the fact that Jennifer McCabe Googled how long to die in the cold at 2:27 a.m. and Brian Laughlin went by and saw no body outside that house 3 minutes later. So legally, you have all the support you need to release my client on personal recognizance. There's also a practical side to this, which gets into the financial issues, Your Honor, and I'm almost concluding my argument here. You've seen my client's medical expenses in the past. You've been aware of her loss of income. You've also been aware of the numerous experts, witnesses, investigators we've had to retain to do the job that the Commonwealth either failed or refused to do. Those expenses continue to mount. She has not asked this court for a dime to pay for any of those expenses. We're now approaching a trial date, which we will request today. Those expenses continue to mount and indeed will skyrocket. She cannot afford to skimp on these experts. The stakes are too high. She needs every dollar she can to keep going, and $80,000 is a lot of money that will go a long way toward supporting her defense. To make it clear, Your Honor, we are not making this request without offering something in return. I would submit there's nobody in this courtroom who believes my client is a flight risk. Given the national publicity that this case has generated, which I submit will only intensify as we approach a trial date, my client is one of the most recognizable criminal defendants in America. Where on earth would she go, even if she wanted to go somewhere? But she's not going anywhere. Her family's here, her doctors are here, and given the strength of her defense, as illustrated by the changed circumstances we've discussed, she has every incentive to fight this case and no incentive to flee. She's made every court appearance and has invested herself 100% into this case, financially, emotionally, and intellectually. But if there's any concern at all, Your Honor, my client will dispel those concerns by turning in her passport. I have it. She's ready to give this to the probation department. She's ready to sign a waiver of rendition, any waiver of rendition the court would desire. So on this issue, she's really figuratively putting her money where her mouth is. Giving her passport and a waiver of rendition is far more valuable to this court in terms of assuring her appearance in court than $80,000 is. But that $80,000 is more valuable to her because she desperately needs it to defend herself. So for these reasons, Your Honor, I ask that you help us to level the playing field here. The Commonwealth has unlimited resources. My client does not. I ask that you release her on recognizance and give her the tools she needs to fight this case.
All right, thank you. Do you want time to provide that affidavit to me?
I'd be happy to do that, Your Honor.
How quickly can you do it?
We have 1 week.
Okay,
Thank you.
yes. Mr. Lally?
I'm sure he's
Very
going to
briefly,
say
Your Honor.
everything is that he just said is bullsh. Sees all the guilties. I'm just
The
kidding.
Commonwealth just requests that the bail remain the same. There's no change in circumstances of the facts, and I use that term loosely as Mr. Yannetti was recounting for the court. Notably absent from his motion in regard to the apparent hair, which I've gone into great detail to explain. I won't bore the court with that explanation again. But what it leaves out is, again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of which being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros, that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as
Okay. Again, if they were living together and he even brushed past the tail light at one point, and goodness knows, I run into doors. I don't know if anyone else has problems with this, but I tend to not judge corners well, which makes me which is the reason I don't use the Rascal scooters in the stores, even though I probably should sometimes on bad days, because I have no spatial awareness. So I don't know if maybe he's like me, but I always miscalculate corners. So if he brushed along, the tail light at any time and then say that tail light broke or was broken, then inside, yes, if you broke it and there was some DNA already there and then it went inside, yes, you could have DNA in there. Am I being crazy?
what counsel states as
I'm not a
Mr.
criminologist.
Lawfren's testimony goes into a great detail in the motion as well. What he leaves out, though, is that all these insinuations that the Ford Edge somehow belongs to the Alberts or Brian Alberts Ford Edge or something to that effect. What he leaves out from that interview with Mr. Lawfren is that Mr. Lawfren specifically says that Ford Edge is not Brian Albert's Ford Edge.
I'm not quite sure.
Another sort of interesting issue in relation to the affidavit from the investigator in regards to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Lawfren out to the parking lot, points to a Ford Edge, and essentially says, "Is that it?" Somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence. I guess now it's being positioned that he was spring.
I'm sorry. Apparently, the entire audience is like, we are bullsh are we? Well, yeah, look, and apparently everyone else who has the ability to see pictures and read Facebook posts are like, I is confused. Did we not just see pictures of them at like weddings and Facebook posts where they're like bestest friends? I mean, okay. But
Sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing. I'm not going to go over again and again the issue as far as Ms. McCabe's search on her phone. The court has been provided numerous reports from forensic experts disputing whatever Mr. Green's findings are. Counsel seems to want to choose or pick and choose as they do with each particular piece of evidence or each report as to what they want to highlight. But the conclusions from Ms. Hyde's report are clear, that from her analysis of that search was conducted respectively at 6:23 a.m. and
oh, Turtle
6:24
Boy
a.m.
is having
It is not a
oh,
mystery
Turtle Boy
as
is
to
having an
when that
aneurysm.
search was conducted or why that search was
Can we
conducted. It was
embiggen
conducted
Turtle Boy?
by Ms. McCabe at the bequest of the defendant. As far as anything pertaining to Ms. Reed's
Reindeer,
financial
why can't we get
resources, again, those
an
were filed ex parte.
I demand
And
Court
as the court,
TV have
so
an
I really can't speak to
embiggination
those.
camera
All I can
only
speak
on
to as
Turtle
far as
Boy's
financial
face. Can
resources
we
is
get that happen?
this case
Can
was
we make
initially
that
arraigned in the
happen?
Southern District Court. The court set a cash bail of $50,000. The defendant posted that within minutes. The defendant was then arraigned in this court. The court set a cash bail of $100,000 initially at arraignment in June of 2022. That bail was posted within minutes. If
She
the
needs
court is
the money for
inclined
her.
to reduce the
Fine,
cash bail,
then you know what? I say if she doesn't get a lower bond, then start petitioning the court for all of her experts. Screw the court. I am so done with this court.
I don't think it's of much moment to the defendant, Ms. Reed. But if it were, I would ask that some additional conditions be set in place, similar to what I had asked for previously on the February date. If the court weren't
You
inclined,
dropped it.
I would concur with surrendering her
Gravity is
passport. I would
real.
concur with executing a waiver of rendition. And I would ask that there be an additional order the defendant be ordered to remain alcohol-free, subject to random testing with a scram device, based on the nature and circumstances and based on the indictment she faces in this court. Thank you.
Okay,
If I may respond briefly to 2 points, Judge.
okay.
This attorney's like,
With
kiss
regard
my
to
ass.
the DNA being a match or a presumed match of John O'Keefe, what Mr. Lally didn't tell you is that that sample was a mixture of John O'Keefe and 2 unknown people. So I don't know if the Commonwealth is changing its theory again to say that my client struck John O'Keefe and 2 other people, and the other 2 people somehow got away. But that doesn't make a whole lot of sense.
Oh.
The second thing is, with regard to the Ford Edge that
Oh,
Brian
Turtle
Laughlin
Boy.
saw outside that property, I would say 2 things. Number one,
I'm watching the Karen Reed case just
assume
because
it
of
was
Turtle
not
Boy.
Brian Albert's Ford Edge. It doesn't matter
Listen, I'm
because there
sending
was
him
somebody
an
there
X, and I know
outside
I'm a
the
small
property
channel, but
where
I
the
want to see
body
if
was
I can get
after
an
2:30
interview
a.m.
with
They
Turtle
would have
Boy,
either
because
seen or
look,
not
his
seen a
face is
body
on 11,
and
and my
known
face
or
is
not
always on
known that there was a
11.
body there. But finally, with regard to that point, Mr. Laughlin was clear that it was not Brian Albert's Ford Edge. What he
Yeah,
did
I'm gonna
not
have to watch it from the
tell
beginning.
you, what Mr. Lowry did not tell you is there's another member of the Albert family that has a Ford Edge, and that's Colin Albert.
Okay.
This is the best. Hollywood writers, screw you all. You guys fluffed up Willow. You fluffed up Luke Skywalker. You fluffed up Indiana Jones. You know what? From now on, we're watching this. Friberto, if you go through all of these in a day, I'm going to have a. You're already. Oh, I don't know. Since it's live, I can't do it, and I'm sorry. I'll stop talking. We will rewatch because I don't think.
So, Mr. Yannetti, I need that affidavit by next Friday, so I'll take this motion
Thank you,
under
Ron.
advisement.
Appreciate it.
All right, so I said at the beginning that we need to set dates. And it's been mentioned that there have been a couple of pretrial conference dates. There have, but council have not complied with the Superior Court standing order that we need to get back on track. So Superior Court standing order 2-86. So we need to set some dates. And council has to comply with Rule 11 of the Mass Rules of Criminal Procedure regarding the pretrial conference. So I'm going to give you a date for you to fill out the pretrial conference report and do everything that you're supposed to do pursuant to Rule 11. We need that before we can go any further. And in that report, you need to outline dates for filing of motions. So I have some suggested dates, given that we were able to work out the discovery issues today. So I think all non-evidentiary motions in this case must be filed by November 16th. I don't want any more piecemeal Rule 17 motions. If there are piecemeal Rule 17 motions, you need to put in the affidavit why those weren't handled when they're supposed to be. I would like January 5th for filing all evidentiary motions. and February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Your Honor, it would be the defense request, and we're open to the specific date, but we would like a trial date in March of 2024.
Okay, that's great.
Early March would be better if it's available.
So we have a trial that's starting in January, a retrial that last time.
Okay, I am gonna go back and start this at, the beginning because it looks like the defense just, kicked ass and took names, and, it was all the hilarious, and apparently there was crowd participation. Okay, okay, okay. Down, Hubert. So this is the Karen Reed, trial. She is accused of backing into her boyfriend, who was a police officer, but it is all of the shenanigans. It looks like it is all of the cover up, all of the shenanigans. The police are trying to set her up. So we will be following her hearing since, since I was on time. Uh, of course, the footage for the Gareth Pursehouse case is totally late. So this is the Karen Reed hearing, and I will try not to talk. Now, there won't be closed captioning because this was live, if you will, and this is court TV. So here we go. But while she's just not using her mic, I believe this, uh, when it came in, the defense is asking for a decrease in the bail money so that they can start paying experts. The state has been, dragging its heels on getting discovery to the defense. The defense has been basically having to pull teeth to get any sort of evidence for their experts to look at in order to start getting a defense pulled together. It's been almost 18 months, and they hadn't been able to get the car back or anything else to start having their experts test anything in this case in order to start putting together a defense. The state has been claiming that, hey, this crime, we've had a lot of crime, we've got a lot of, our labs are all the things, the coof, aliens, whatever, which is, astounding because the defense has pointed out in other hearings that they were able to get DNA through in like, I think 13 days in another case. So this case has been all the shenanigans. The courtroom seems to be full of people that really have kind of latched onto this case. There is a YouTuber called Turtle Man, who I will try to send a DM to. I am a super small channel, so I don't know that he'll have time to talk to me, but if he does, that would be super awesome. I don't know that it will happen, but we will see. And he has compiled an entire list of shenanigans up to, I think, 110 installments now. So if you really want to get deep into this case, you can go look at that. Has done a great job. I thought I would have super amounts of time to dig into this, but between Delphi and Six Children and Doggo, oh, Turtle Boy, not Turtle Man. I'm sorry, Turtle Boy, but he is an adult human male person, so I didn't wanna call him boy 'cause he's Turtle Boy. Um, fine. Any hoozle, that is what they're talking about. The prosecutor has no friends in this courtroom. Yes, this is the one, at the cop party, and they're claiming that she ran over the boyfriend, when he clearly looks like he was attacked by a dog and got the snot beat out of him. Uh, the scuttlebutt is that he was talking to internal investigations about either a dogfighting ring or something shenanigans wise going on, and other cops found out about it, were not too happy, and retributionish stuff. So there's a lot of things going on, but basically this hearing, we kinda came in the middle, and it's all the fiery, so we are starting at the beginning. But, this has this is all the cray, so the judge doesn't know how to use her microphone, everything is right at the world. Good morning, Kim and Shenanigran and Bobby and everyone. Now, it is concerning that the state has been dragging their feet so much on discovery. I'm seeing a lot of parallels with this and the Delphi case. The state has been really reticent to give up discovery, has been dragging their feet up, has, been delaying, things like that. So it's oh, I love you too, Salbert. You know me. You're my twin brother. Oh, for I don't know if they didn't turn on the mics for this part. The sound was working just fine. I think they
With regard to Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from, or with, related to Mr. Lally's motions,
okay, the
NBC,
defense knows how to
ABC,
use their
alarm.com. Is that what the court's talking about, or the,
okay, so Turtle Boy, you don't see him yet, but
right?
he's the arm you see holding his leg next to the gentleman with the, IT goatee, uh, and it looks like the 3rd row.
Not completely. As it relates to the town clerk, no issue. As it relates to Google Nest and Google, we have no issue. As it relates to NBC and ABC, I have no issue with alarm.com, but the other two motions that the Commonwealth filed Rule 17B motions on, I do have an issue with, because I don't have enough information to be able to state with any authority that they have not received third party, consumer notice. However, in speaking with both those entities, producers at both those entities, I have not spoken directly to legal counsel on either side, but for either agency. However,
Look,
I
I
was
don't even
told
know
by
anymore.
individuals who had spoken to legal counsel that they had not been served, they had not received any formal paperwork from the Commonwealth as yet. And that was probably, I want to say, 5 days ago, something like that, 5 or 6 days ago. So that's the latest information I have. In other words, I don't have information that they haven't gotten notice, but I certainly don't have information that they have gotten notice either.
Well, I think I'm a chest feeder now or a non-dangly bits haver. I don't know. Yes. I
That's satisfactory with us, Your Honor.
Where did you get a chicken nugget? You know what? I'm not gonna ask.
Take a close look at the order. All right, so why, 116, and now we'll go to the Google Nest motion, Rule 17 motion, paper number 125. Mr. Henning, why don't you come up since this affects your client as the third party? Okay, so why don't I hear first, I just like you up here, why don't I hear first from Mr. Jackson? Sorry if it makes it uncomfortable for you standing there. Why don't I hear, I guess you'll have to take a seat. Why don't you just sit down? Thank you. I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
Thank you, Your Honor. There's very little question that the security camera footage capturing the interior and exterior of the Albert home, the scene of John O'Keefe's death, is evidentiary, it's relevant.
Okay,
it's
so that's
material to the
Turtle Boy
defense,
back there by the
and
bailiff
should be material to the prosecution, I would think.
that
it should be
apparently
I
is
have
just
a proposed order from the
mugging
Commonwealth,
for the
so I don't
camera.
know that there,
So be sure to watch Turtle Boy's face if you ever have an ADHD moment, because his face, like mine, goes to Spinal Tap 11. He has an all caps face, and it is hilarious.
there is that much of an opposition to
There may
this.
not be, but there may be an opposition from, it sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts on the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26
I do
pages
not know.
of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time. A grand juror had to step in and ask that question. And that's interesting in and of itself, but this is a longtime law enforcement officer, Brian Albert.
I'm actually going to interrupt you. Mr. Lally, is there any objection from the Commonwealth?
So as it pertains to the motion being allowed, no. The only objection, and that's why the Commonwealth filed a modified proposed order, because it's seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning, Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client. It will save us some time if we direct it to the order if there's no
I do
objection.
understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm
as
going to
it
ask you to
pertains
have a
this.
seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
Good morning, Your Honor. Craig
Morning.
Henning on behalf of the homeowner. With the proposed order that the Commonwealth submitted in mind, that language, Mr. Albert, the homeowner, has no objection to the Rule 17.
Thank you. All right, I'll hear you now, Mr. Jackson. I don't know if you heard that. Did you hear Mr. Henning?
I think I heard him say that there was no objection.
To the proposed order from the Commonwealth.
The proposed order, the problem with the proposed order of the Commonwealth is it indicates that they believe that the information is appropriate prior to January 29th, which is in and of itself ridiculous. The whole point is to get the camera footage from the 29th, from the early morning hours of the 29th. We don't have, again, this has become a sort of a theme with the Commonwealth. They indicated they wanted to change the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage from the 29th. And I question whether or not that was as the Commonwealth.
Did you see number 3 of their proposed order?
Proposed order is.
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
Number 1 says activation or setup information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's 1. Number 3. The Commonwealth's proposed order is more expansive than the defendant's proposed order. If there's an objection to that, I'll hear you.
Now, obviously, there's no objection to us expanding the time. We want it as expansive as possible.
I just want to make sure you have the motion. Do you only have the first page of it?
No, I've got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor.
We both received it. I mean, I can read it on my phone as well as I can read it on a piece of paper. My issue is, as I indicated, I want to make sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So as long as that proposed order includes and encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number 1 that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number 3 is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case. So the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number 1, excising any sort of other Google account information. Which
And I
is
think Mr. Jackson
relevant.
just said he didn't have an objection to that. All
that
right,
and expanding the time frame. That's
okay.
it.
The only wording that was changed under number 1 that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, any setup inclusive of January 29th, as well as the end of that same paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale to our knowledge of a Google Nest activation system. In other words, the setup, I think that's a throwaway line and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. Sum and substance is that we get the Google Nest data. That's what we're concerned with.
All right. And you'd prefer that I add the expansive time frame than the
Correct.
less restricted time frame
Correct.
that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. I'm going to hold on to it because I'm going to take a look at the orders more closely, but Rule 17 is allowed, no objection from the homeowner. So thank you for coming in for that, Mr. Henning. All right, so now we'll do the Commonwealth's, the motion for the alarm. Is there an objection to that, Mr. Jackson or Mr. Yannetti or Ms. Little?
Not from the defense.
Okay. So this is the Commonwealth's motion for records alarm 121. Did you propose an order with this, Mr. Lally or Ms. McLaughlin? Did you propose an order that maybe I don't have?
Should be an order attached. I can provide the copy with an additional.
You might have it, Jim. All right,
This woman has
thank you.
ASMR.
Thank you.
I need more caffeine for her voice, is what I'm saying. She'd put me to sleep. She's putting Fry to sleep. But that's not hard to do. I think he's going through a growth spurt.
All right, so Jim, I can give you back that whole motion. All right, I'll hear the Commonwealth. Do you want to start with, I have first the ABC News one. Why don't I hear you on that?
Just, it makes no difference to myself, Your Honor, but there's also another related motion to that camera.
Which is to the camera one?
Yes, from the House indictment. It's a motion to compel, to preserve, and
I don't-
request for order production.
I don't believe I have that. When was that filed?
Same time as all of the others.
It could, I mean, I just have copies, so it could be that it was that. So Jim, it's probably somewhere around 121, maybe 123. Is there an objection to this from the defense?
No.
Thank you. All right, Jim. All right, so why don't I hear you? It doesn't matter to me whether it's ABC or NBC that you want to start with.
Your Honor, I think we can take them sort of in tandem. It's essentially the same issue, the same type of factual background. Essentially, what the Commonwealth is requesting is any and all video footage, including raw or unused or unaired video footage of interviews, specifically with the defendant herself. She submitted herself to interviews with multiple news programs. The content of those interviews was sort of interwoven within a narrative story, which the Commonwealth would submit as a fair inference that there's additional footage that is available. In specific reference to the NBC, there's an indication from the broadcast that this is part of a larger program to air at a future date. These statements by the defendant, as the court is well aware, are entirely admissible. They were freely given by the defendant. In each of the respective news broadcasts, the defendant, at least in part, so some of the statements she's on her own along with the reporter, and some of the other statements she's seated at a table with counsel. So as it pertains to any of those statements, there's an exception to the hearsay rule as far as statements by a party opponent. Any statements that she makes to these outlets, she's free to make, but the Commonwealth is seeking production of those statements.
Okay, who am I going to hear from the defense?
Your Honor, at this point, we don't have an objection to Rule 17. I think as a matter of fact, I know there's going to be a
Speak into the microphone.
Sorry.
Good Lord, all of you. I'm making a
It
clap.
will just be closer to it.
Sorry about that. We don't have a principled objection to Rule 17 because it's really not our dog in the fight, as it were. In terms of ABC and NBC, if the subpoenas issue, I have every reason to believe that both NBC and ABC's legal department will take great issue with the subpoena for reasons of their own. But the defense is not taking a position on the Rule 17 at this point because it's not our fight.
Okay. All right. So do you want the opportunity to speak to legal counsel and see why they weren't represented here today, Mr. Jackson?
I would like that opportunity. It is unusual, I think. I suspect that there may have been, and I don't want to speak for the Commonwealth, they know better than we do. Both NBC and ABC are out of state. I don't know that they were
Of
served out of
course,
state,
of course.
right?
I think the Commonwealth, yes, they're
I'm
served.
not
It's
sure.
right in the pleadings. It's
But I'm
right in
not
the
sure
pleadings.
where they serve notice. I just don't know, because when I did check, both legal counsel, both offices, general counsel for NBC and ABC indicated to me through another person that works there that they had not gotten any information concerning this issue. So I would like an opportunity to check with legal counsel.
Okay, so
Because as a party
I
of
will,
interest, she does have an interest in it.
I will take the motion under advisement.
What happened?
If they want to be heard, I will give you 1 week for them to give notice to this
I have
court.
no idea where that came
By
from.
way of letter of legal counsel as to why they did not appear here today. And
Understood.
then we can see about setting up a hearing. And if your position is that you don't object to it and it's just with them, we'll set a date.
Thank you, Your Honor.
All right, so I'll do the same with both of those motions. All right, why don't we do the motion to compel, and then we'll get into the exhaustive testing motion. Is there an objection to the exhaustive testing motion?
At this point, Your Honor, there is.
Okay, so we'll hear
there's
the
some technical
motion.
reasons, but
We'll do the motion to compel first.
thank you.
And so when this motion was first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response to the Commonwealth's opposition. So I think that's where we have you focused. But has that changed at all since you filed this?
Oh,
I received
interesting.
additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received. I did receive a packet of information today, but I'll go through that for the court.
Okay, go ahead. So let's do what you address in your reply.
Thank you, Your Honor. It has now been a year and a half since Ms. Reed was arraigned in Norfolk Superior Court. A year and a half, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months and has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor. It
Okay.
includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person.
Are they sending
This is
these
the
things to
seminal
Sri
evidence in this
Lanka?
case.
What the crap?
Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12, 2022. The compliance date for mandatory defense access to this physical evidence was more than a year ago. In opposing this motion, as Your Honor noted, the Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says, we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago. And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th
Okay, you're
of
going
this
down,
year,
sir.
Mr. Lally
No
stood
findings.
here in open court and made these promises. Quote, I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation, from what I'm told, is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in discovery about a month ago, this is what you see. Quote, note to file, date January 3rd, 2023. Entry by John Buello, person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report. And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court to order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires. That brings me to the second category of evidence that we're missing. Your Honor, for quite some time, we've been asking for access to the Lexis infotainment system and the Lexis telematics system. As of this morning, our expert was able to get in touch with Trooper Garino, and they're currently working on coordinating a time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis. If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court, but I'm hopeful it won't come to that. The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes taken in connection with this case. That was done in Stoughton District Court on February 2nd, 2022. And I know Your Honor sort of reaffirmed that order just in passing during one of the court appearances when we asked for her to renew it. We know law enforcement took copious notes in this case because Most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of a court order. The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information should have been produced over a year ago. If you were to review all of the police reports in this case, as we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road that resulted in the recovery of taillight pieces. Those searches were on January 29th at 5:45 p.m. by the CERT team, and there was a second search on February 3rd, 2022. But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th,
Oh,
Trooper Proctor claims to have actually
I guess it's up to chat. All 3 other of you. Am I gonna need a day drink? This is all shenanigans. I was just about to type. I guess if I am okay with it, if you guys in chat want to hear it, that's fine. If you guys would like, I can let me see. I can try to snipe. They have yet to put the footage up because of course they haven't. Because why would they do anything? Uh we can snipe from whatchamacallit. Well, I have to pick up my kids, so I won't be able to drink until later. Oh, all 3 were found not guilty. Well, isn't maybe because they spent years and years and days and months talking about other folks. Oh, okay. Well, I'm not this is okay, well, we're back to
actually
Fornicate
recovered taillight
Friday, and
pieces over the course of 5 additional undocumented searches of the Albert residence throughout the month of February.
no one
The
likes
only reason
Gretchen
we even
Whitmer.
know about these
The
searches is
verdict is
because when
in.
Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of
In
taillight were
Sargon of Akkad
supposedly found.
fashion, I wouldn't
34 Fairview.
even ...
That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No notes, no reports, no photographs of where those taillight pieces were found in the yard. No memorialization of the individuals who called Trooper Proctor to the scene. That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date for the production of these notes and reports so that we can at least attempt to prevent further fabrication of evidence. The 5th category of evidence, Your Honor, is the raw data associated with the CERT team search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case. So I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set a compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
Your Honor, I'm not quite done.
Oh, you said there were 5.
I was going to have a conclusion if I may
Okay.
finish addressing the court. Thank you.
Sure.
Your Honor,
What?
we are entitled to this discovery and we need compliance deadlines. Ms. Reed has a constitutional right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's entitled to. Thank you.
Thank you. Come on.
He's gonna be like,
Sure.
we're trying our best. It's
Most
not
of
off.
what I believe was just addressed was dealt with in the Commonwealth's response.
Sure, he's speaking in a microphone right in front of him, but if you can't hear him, can you go over to the podium,
That's
please?
fine. So, Your Honor, I believe most of this I've addressed in the Commonwealth's response. And just to be clear, it's not an opposition to the defendant's motion. The Commonwealth is well aware of its discovery obligations under Rule 14. It does not oppose.
If you want to see why I am laughing, Turtle Boy's face. I cannot in biggin, but I can in pausin. And I believe if you can just the cursor, how does Dave get to draw on his thing? I must learn how, is he using OBS? Is that how he can draw? But this face right here, oh my God. Sir, look, I know I'm a small channel, but your face is akin to mine when it comes to bullshittery and not being able to control our face movements. Yours is all caps and so is mine. So, oh, it's a plugin? Okay, I'll have to. Dang it, Dave.
The defendant having access to these items. It's merely an issue of timing. Now, as
Sure
it
it is,
pertains
Jam.
to the first enumerated item, and there's been various modifications of this, and what I would say is that the Commonwealth is
Thank you,
very
Sal. I
aware of its
appreciate it
ongoing
very much.
obligations under Rule 14A1A, under Rule 14A4, as it pertains to mandatory reciprocal
Yes, I
discovery
do.
and exculpatory evidence, and has provided counsel for the defendant with we're close to 300 items of discovery at this point. So this is not a situation in which the Commonwealth is I would submit, withholding evidence or preventing the defendant from receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel.
Well, mistakes
There was
have
somewhat
been
of an
made
issue
on
at
both
some points
sides,
over the history of this case where I had been providing discovery to
and
Mr.
I
Yannetti
I
that
claim
apparently
it.
wasn't making its way to either Ms. Little or Mr. Jackson. My remedy for that has been to provide whatever I can, especially documentary evidence and attachments, email, so that it goes to all counsel and all counsel have access to it, which caused some of the delay as far as the testing in the lab is concerned in the first place. The lab was prepared to conduct its initial DNA testing back in May, had to wait until July, and then there was a second subsequent exhaustive testing, which wasn't conducted until August 1st because of the timing in which we received the exhaustive authorization form from counsel. What I can say is Ms. Little and Mr. Jackson were very good as far as soon as they were made aware of the issue, they executed the forms. I received them, forwarded them to the lab the same day. But unfortunately, all of the DNA testing was not able to be completed on that July date because of how late we received that particular assignment. As far as the items that are contained at the lab, again, these are the lab's policies. They're not my policies. There's nothing as far as anything that the district attorney's office or myself has done, any suggestion that we're desperately withholding evidence from the defense as we're afraid of what it might show is just patently ridiculous. The items that are at the lab are, there's no objection
Not
to
patently
counsel swabbing
ridiculous.
anything from any of those samples, inspecting them, photographing them, doing whatever they would like with them. The issue is when the lab is done. And as I detailed in the motion, there was a recent trace assignment that was completed, not recent, but several months ago, actually. And it had to do with item 3-1 and several other items pertaining to the taillight. And so 3-1 is the passenger side rear tail light of the defendant's SUV. Items 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual unit from the defendant's SUV. That was believed to be done. So the lab at that point had made a forensic link and was believed to have been done with testing related to that. Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately, probably less than 1/16 of an inch of clear and red plastic pieces that were recovered from the victim, Mr. O'Keefe's clothing, specifically his shirt. Based on that discovery or analysis, there was then a subsequent trace assignment that was created in relation to comparative testing for those microscopic pieces to item 3-1. Again, an item that the lab had theretofore thought that they were had completed with. There's also an ongoing trace assignment for comparative purposes to some glass that was recovered from the rear bumper of the defendant's vehicle, comparing it to pieces of what they describe in the lab notes as cocktail glass that's found on the ground near Mr. O'Keefe and near Mr. O'Keefe's shoe. Of note, what I would say is that Mr. O'Keefe is observed leaving the Waterfall Bar last time that he's on video, carrying a short cocktail glass in his right hand as he's leaving from that facility. So that trace assignment is open. The DNA results from the July testing has been completed and provided to counsel. The DNA testing results from the August 1st testing.
Look, I know that the writers' strike is going on, and we are all desperate for Hollywood not to come back and ruin Willow and Luke Skywalker and everything again. Can we just have Turtle Boy reacting to stuff? Because it would be entertaining for me. I would watch it.
My understanding should be completed. And again, these are not promises that I make. These are estimations based on what the lab can tell me as far as their expectation of when items will be completed. But the DNA testing I anticipate should be completed on or around September 26th. Those 2 trace assignments should be completed sometime in the last week of October. And there is additional DNA testing that has just been scheduled to be undergone shortly. As far as whatever the court deems appropriate to impose, obviously the Commonwealth will comply with that. We'll make arrangements with the lab. They do not allow outside personnel into the lab, so it'll be a situation where obviously items that are currently undergoing testing are not going to be taken back from the lab, but if there are any items that have no forensic value left to the lab, once this sort of round of testing is completed, we will certainly pick those items up and make them available for counsel. But
Do you anticipate that this will be the last round of testing for DNA?
I anticipate it will, but at the same time, it depends on what the other testing shows. So it's typically what the lab is going to do is they're going to test until they get a forensic link, or either they do or they don't. But basically, so without knowing what the results of the testing that's just undergone and is just about to be undergone or is undergoing currently, I can't speak as to what those results would be, and therefore I can't speak to whether or not there would be any need for additional testing.
Okay.
As it relates to the Lexus infotainment and telematics, I'm just a little confused because initially how it's phrased in the motion that compels, it's sort of incorporating all kinds of different materials. So it's talking about an ACM, EDR, LSS. Now the ACM is the airbag control module in the car. EDR is the event data recorder. LSS is the Lexus safety system that's specific to a Lexus. All of those items are in the vehicle. And I've endeavored to arrange, should counsel have an expert that wishes to view or download that material directly from the vehicle themselves, all of that material, including the raw data, has already been provided to counsel. Way back in May of 2022, Mr. Yannetti had retained a reconstruction expert who had actually gone to the vehicle and downloaded the ACM material. So I'm just, what I was told most recently is that they don't need to look at the car, or they don't want to meet with Trooper Paul from the CARS unit to do anything with the car. As far as it pertains to the Burla and the telematics, as I've stated previously to Your Honor in court, the issue is, and just for the court's understanding, the Burla is, think of the Burla as a Celebrite for an infotainment system. So it's essentially the software that downloads it. The issue is that Burla, which is essentially really at least the only certified forensic tool that I'm aware of that pertains to those types of systems. They receive updates periodically from the manufacturer. I believe there's another one coming up in a month or so. But I have no information. We reached out to Berlin numerous times, but I don't have any information as to whether or not this make and model of a Lexus is going to be part of that update that they provide. But up until we receive an update that can actually read and parse the data that's contained therein, it's an issue as far as, you know, there has been data that we've extracted and we provided to council, but it's essentially unreadable data at this point. I am aware that Trooper Garino from our office spoke with council's expert yesterday, actually, in regard to seeing what can be done, what had been discussed, and what I had discussed and discussed in the Commonwealth's response is what's called a chip-off. Now, a chip-off is something that doesn't just pertain to the burglar or to the infotainment system. It also would apply to an event data recorder. It's the issue with the chip-off is that it can be and likely would be destructive. So essentially what it involves is sort of burning the chip off of the unit. And in that process, sort of inherently within that, can be destructive to whatever data or material is in there. And you don't know that until you've already completed the process and started to look at it. And that is a reason that the Commonwealth has not endeavored to do that at this point and has opted to wait and see sort of if we can get an update from Burler or from the manufacturer to Burler so that we can read and parse the data. If that is something that council is interested in doing, again, I spoke to Ms. Little a little bit about this, that the Commonwealth certainly is not going to conduct any of that testing without them having an expert present to do any sort of chip-off or any kind of destructive testing whatsoever. But if that is something that council is interested in, I would encourage council to file a motion with the court, as would be done with any sort of destructive testing. And if that's something that the court orders us to do, obviously we will be present and council will have an opportunity to be present with an expert as well. The third category, I believe Ms. Little was referring to notes of law enforcement. Absolutely no issue with that. It's been requested. I should have those in a short frame. If the court wants to order their production within, say, 2 weeks, that's absolutely fine.
All of them?
Reports, notes, and mapping from the CERT team. Again, these are items. What Ms. Little was referring to today is a GPX file that I just received yesterday from the CERT team, and that's why I'm providing it today. Obviously, sending it in the mail wouldn't do as good as handing it to Ms. Little today. But essentially, what I put on that disk is a GPX file, and it's a file that contains data that can only be opened in a mapping software. So in addition to the GPX file, I also put some mapping software onto the disk to make it readable. If council wishes to use a separate software application, obviously they're free to do so.
When do you expect to be able to do all that?
So that was provided today. The other part, as far as notes from the CERT team, there are no notes from the CERT team. I spoke to Lieutenant O'Hara from that unit. There are no notes. They have reports, they have diagrams, they have the mapping raw data. The only thing that I'm currently waiting on and should have in the next few days or so is in relation to, I don't even know if they asked for it, but it's something that I was looking for as far as dispatch logs and ALV data as far as when they were dispatched and when they arrived at 34 Fairview Road, all of which should be logged. Similar to items that's been previously provided in regard to the Norfolk County detective units. As it pertains to Trooper Proctor, 5 undocumented searches of the residence, I don't believe that those occurred. I will certainly look into that. And if there is any documentation related to those, whether they be notes, whether they be photographs, whether they be reports, again, the Commonwealth has no issue.
Today on Fridays with Mo and Fry, it's Mo reacts to Turtle Boy reacting to Karen Reed's
Providing those in short order. That's something that I've heard of
hearing.
the first time today while I was sitting here in court. Now,
I
the
needed
fifth
this
thing
this Friday,
pertains
which
to
is
the raw data,
terrible
which
because a
again,
woman's
the
freedom's at
Commonwealth
stake.
provided this morning. So as it pertains to this or any discovery, there's been a number of other discovery items that Ms. Little and I have had conversations in regard to over the last several months, over the last however long it's been. But I would submit that when I'm asked of things, asked for discovery, formally, informally, whether by formal motion or not. The Commonwealth has no issue with continuing
The
to
bailiff has
abide
been informed to block
by its
Boy's
duties and
face.
obligations under Rule 14. Whatever discovery I have or whatever discovery that I can provide, I'm happy to do so. That is,
Okay, Ms. Little, any follow-up with that?
That dude just lied his balls off. That's what we were saying.
Mr. Lally just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately. There's no reason to continue to withhold those from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not going to have our expert fly out to do that until she can actually look at the stuff that's of substance, which is the infotainment and telematics system. As far as that's concerned, I know Mr. Lally has made representations to this court that the infotainment and telematics system have no recoverable data and have been hooked up to Burla. But Burla is just that. It's like Celebrate. There are hundreds of other softwares out there that are able to read and parse this data. Our expert is aware of what those programs are. She would like to be able to analyze the data. She believes that there's likely ways to do it that are non-destructive. She has reached out to Trooper Garino to inform him of this. He seems to be receptive to doing that.
Okay.
She won't know until she actually looks at it what particular softwares will be appropriate. We haven't been able to get that information from the Commonwealth because the actual photographs and things she needs to look at to see how to analyze the data, we still have not received from the Commonwealth.
So you say that your expert is talking to the Commonwealth's expert today or yesterday?
Yes, I believe actually this morning is when I
Okay,
received
so
the email.
after they talk, if you put in writing to me a protocol that you say your expert says there's hundreds of other methods of being able to read this data, put something in writing. It sounds like the 2 experts should be able to work it out, but if not, we'll deal with that. But I do want to know about that.
That's my hope. Thank you, Your Honor. With regard to the 5 undocumented searches, we don't have reports on those. Like I said, we have photographs of the evidence bag that shows that taillight pieces were not put into evidence until late February. There were 5 undocumented searches. They came from somewhere. So we need reports on those. And with that, I will submit, Your Honor.
Mr. Lally, earlier when you talked about the DNA, you said that on 9/26, one item, the testing should be complete, the other, the last week in October, and then you said the third, you were looking for a date, but I think you said soon. Do you know when whatever the third part is that you were talking about?
So to be clear, the 9/26 date was in reference to the DNA work that was completed on August 1st.
Yes.
That was a second round of exhaustive testing in which their expert, Mr. Lakin, was present. Then we had to delay because of first his availability and second not having the exhaustive testing form completed. The second that I was referring to in late October
so it's
is in
their
regard
fault.
to 2 separate trace comparison analysis. That's sort of the estimated time of those reports completion. And then there is a subsequent 8 items that have been selected by the lab. And just to be clear, these are items that are selected by the lab, not by our office, for DNA testing that has just, they don't require exhaustive testing. So that has just begun to be, I think it's scheduled within the next week or 2 to undergo that testing. And then just my own sort of estimate as far as typical turnaround time for DNA, in which, it has been communicated to the lab on numerous occasions. Every single bit of testing that's been done, as per the court's suggestion and direction, I've requested expedited analysis with regard to each of those. So that I would expect probably around the same time frame, late October, early November, as the trace comparison.
All right, so what I'm going to do is I'm going to order expedited testing on those 8 items that have not yet been tested. And I want the Commonwealth to be able to report back in the beginning of November the results of all of the testing that's been completed. And if it's not completed, why, and when you expect it to be completed. Why don't we have all of that by November 3rd? For B, the defendant's request number 4, for the infotainment, I do want the 2 experts to talk. I need more information on this. If it's something that there is other software that can read this, then we can move quickly with it. So I need to get that from you, Ms. Little. You need to talk to the Commonwealth. Your experts need to talk, and you need to put something in writing for me on that. Stand up at the microphone so I can hear you.
Can we have a compliance date for discovery from the Commonwealth so we can get the reports and the photographs we've been asking for so that our expert can make that analysis? She needs to know exactly what's in the car and have pictures of the circuitry.
Your Honor, if I could just speak to that. So the photos are on a disc and in the papers that I handed to Ms. Little this morning. Also, when I spoke to Trooper Garino, he indicated that following his conversation with Ms. Gaffney, who was the defendant's expert, yesterday afternoon, that he had forwarded an email with each of those photographs to Ms. Gaffney directly.
Okay, so if you talk to her today, if she still needs them, put them in writing and we'll order them to be produced. All right, so the request D, is the Office of the Medical Examiner, is that all taken care of? The original death certificate? You didn't raise that this morning, Ms. Little?
Yes, Your Honor.
Okay, so request number 5 is all set?
Yes, Your Honor.
Okay, so regarding the request for all of those notes, a 2-week date. So let's get that by the 29th of September.
They couldn't even get the original death certificate without this
I'll give you the
little
same
dude
time frame to see about whether
being
there are any
made to.
photographs,
I
handwritten
love
notes,
Cheetos.
mapping, documenting the recovery, the 5 undocumented searches that are outlined in E of the defendant's response, reply to the Commonwealth's response. So 2-week date for that, 2 Commonwealth 929. The Commonwealth says that there is no raw data with the CERT team or no notes. Why don't you just tie up all loose ends and put that in writing, Mr. Lally, by 929?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Okay. That was the whole purpose of today's hearing, was to be able to do that. So at least we've got that done. Now we move on to the Commonwealth's motion for an order regarding expedited testing. And the Commonwealth has asked me, I believe, to impound the results here, Mr. Lally?
As far as the attachments to the motion, yes.
Yes, okay. Is there any objection to that from the defense?
Let me have just a moment, Your Honor.
Your Honor, I'm sorry. Did you say expedited testing or were you referring to exhaustive testing? Is that what you're asking?
Exhaustive testing, the Commonwealth's
Okay.
motion.
I'll let you address that.
So, okay.
Your Honor, there is an objection.
Okay, so let me hear the Commonwealth then on the
Fine.
motion, then I'll hear your
That's fine.
objections. My question was simply on the impounding of the attachments. There's an objection to the impounding of the attachments?
No.
Okay, that was that question. I'll let you be heard on the motion, Mr. Jackson, but I'll hear from the Commonwealth first. And Mr. Clerk, the results that are attached here, Commonwealth satisfied me that they qualify for impoundment, and I will impound them.
Yes, Your Honor. Duration of trial.
Yes, I'll put that in here. All right. Mr. Lally, I'll hear you
Why
on
is
the
Turtle Boy
exhaustive
just smiling
testing
like he
motion.
just won the lottery?
Yes, Your Honor. So very simply put, there is 2 items that, as I just referenced earlier, have been subject to DNA testing in July of this year. Among those items was a the root end of a hair, item 3-6.1, from item 3-6, which was a hair that was recovered from the rear bumper of the defendant's vehicle. The testing that the Commonwealth is requesting would surely be exhaustive based on the size of the sample. The MSPCL, the State Police Lab, does not have the ability to conduct mitochondrial DNA testing or the testing that the Commonwealth is requesting being done in this case. We've identified an external vendor. This item was initially marked by the State Police Lab for an external vendor because of that reason, because of the size of essentially what is the shaft ends of the hair. For those reasons, the Commonwealth is requesting that it be permitted to send it to Bodie Technologies in Borton, Virginia, which is a lab that the Commonwealth and Defense routinely use. I don't think there's any question as to the ability of the lab to do said testing. I've also attached as Exhibit C, reached out to Bodie just because obviously, whereas it would be exhaustive testing, we were curious, or I was curious as to whatever their policy was regarding observation of testing procedures. They do somewhat allow for it, but it's more sort of behind glass. And
It was helpful to me to be able to read it.
So for those reasons, whatever, I mean, that is something I think that is up to the defendant through her counsel as far as how she wishes to exercise that. And I'm sure whatever their choice is can be arranged with the lab. But whereas the testing is exhaustive and it be sent to an external vendor, I felt that a court order was appropriate in order to, prior to sending that sample off and conducting that testing.
So you are not asking that I impound Exhibit C?
It certainly doesn't have to be. I just did it as A, B, and
No,
C.
the only thing that requires.
All I'm seeing is my youngest, most feral because he if on camera, it becomes the Griffin show, and I do believe that the deputies might have been told to block Turtle Boy from camera access.
Requires is A and B, so I'm only impounding A and B.
That's fine.
All right, now I'll hear you, Mr. Jackson, on your opposition.
Thank you, Your Honor. As it pertains to the hair, the history of that hair is somewhat tortured. The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. They've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client. Except when we demanded that the hair be tested under the watchful eye of one of our own experts, which we had not had the advantage of doing at any time prior, it turns out that it wasn't a human hair. On August 25th, 2023, there was DNA testing done on 3-6.1, and the analysis resulted in, quote, no human DNA detected. STR analysis not performed. I'm holding the DNA results. So after a year and a half, so 19 months or so of saying this was a human hair on the back of that bumper, turns out it's not a hair. And DNA testing indicated it was not a hair. And now the Commonwealth seems to be in some sort of triage mode to try to figure out how they made a mistake. And the mistake is, actually, I question whether or not it was a mistake, because you can make a mistake once. I don't know that you can do it 4 separate times. In 4 different filings before this court, 4 separate times after August 25th.
Fries like
After they had
heifer. I
this
am trying to
document in their hand,
sleep.
which the highlighted portion says, no human DNA detected. They filed motions with the following phraseology. Quote, the hair has been forensically confirmed to be a human hair, end quote. Not once, not twice, 4 separate times. And the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase. The hair has been forensically confirmed to be a human hair. Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious and it's intentional. So when the Commonwealth comes to us at the 11th hour and says, oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which would, as Mr. Lally indicates, he's smart enough to know, the lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. I expect that Mr. Lally will say something along the lines of, well, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination on the exact same issue. And it's not like a generalized proficiency exam. It's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. And she failed that. So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it.
Like,
Then they
damn
go
it,
back
woman,
and
I am
DNA
trying to
test it.
sleep.
It comes back
You
not to
harpy.
be a human hair. Then they say we want to destroy it. My position is it should not be destructively tested, certainly not by the Commonwealth. I understand, I know the Bodie outfit in Virginia, the third-party outfit. They've got a good reputation. However, before anybody gets their hands on that hair, I don't even know if it's in.
Oh, Bobby, just wait. It becomes a full-on interactive Rocky Horror Picture Show. I'm surprised people didn't bring their own props.
If it is a hair, quite frankly. Before they get their hands on that item and destroy it, I would ask that that item be made available to us. This protocol is undertaken all the time throughout the country. Have it sent to an expert of our choosing, and we have one in mind out of Chicago, probably the most well-reputed microscopic analysis shop in the entire country. We'll have them employed to look at it microscopically, make their own determinations. At that point, Mr. Lally, myself, we can agree if in fact the results are satisfactory to have it exhaustively tested, but certainly not now, not after this, as I said, tortured history of this item.
Okay. So am I going to hear from Mr. Lally or Ms. McLaughlin, who wrote Mr. Lally, I'll hear from you.
It's not our fault.
Your Honor, as it pertains to the hair, so the analyst responds to the garage of the Canton Police Department, labels it as an apparent human hair based on the characteristics that she observes when she removes the item. The item is then taken back to the lab and microscopically analyzed. There are photographs that counsel has from the lab packet that's already been provided. I would submitting any of those photographs to whatever expert they want. I would imagine would concur with Ms. Hartnett's analysis based on those characteristics that it is a human hair.
Thank you.
I believe what has just been stated is a complete misrepresentation of what that DNA testing report says. So what the DNA testing report says is that there was no human DNA detected. As the court is well aware, there are essentially 4 steps that are done in a short tandem repeat DNA analysis. The second step being quantitation. So when there is an insufficient amount of a sample, and that's why the root end of a hair is the one that's initially tested for DNA, because you're not getting DNA typically in typical DNA testing from the actual strand of
No,
hair.
the problem is that the woman that said it wasn't in fact a human hair was a moron. That's where we take issue. You had a moron on the payroll that started this whole thing. So Marley was dead to begin with. It So what's had started all of this was Moranecy.
which you're using the root end in the hope that there are some
No,
residual
we
skin
all
cells that are
understand
left from
mitochondrial
profile
DNA,
from.
sir.
That's what no human DNA detected means, which I'm sure council is well aware of.
No, what council's going to get back up and tell you, I'm sure, because we hadn't seen this part, is that no, she failed her proficiency, but I'm sure due to union rules, she got to keep her job.
In its representations to the court to the contrary. So the STR analysis is not done on the root end of the hair because there is an insufficient sample for them to even replicate in that quantitative second step. So the findings from the criminologist or the criminalistics expert as a microscopic evaluation of that particular item and identifying it as a human hair is not incongruous with the finding from the DNA that there was no human DNA detected on that particular item. So as far as this particular item being sent, we're not looking to destroy the item. It's based on the item's size that any further DNA testing is going to exhaust the sample. We're sending it to an outside lab, to an external vendor, and that external vendor does provide for some opportunity for the defendant to send an expert to observe said testing. So there is nothing that's being hidden here or kept from the defendant. All items as far as that microscopic analysis are concerned, lab notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel, and we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this testing and bring in the order before the court because of their observation policy and because the likelihood of the exhaustive nature of the testing.
If the testing is to occur, did they give you a timeline as to, I'm going to hear from you in a minute, Mr. Jackson. I just want to know the answer to this question. Did they give
16
you
years
a
from now.
timeline as to how quickly that could occur?
I believe 2 months or so is the estimate that I got.
All right. I'll hear you now, Mr. Jackson.
Jiminy Christmas. No, let's jack up her life for
At the end of the
forever.
day, all we're asking for is to have the item reviewed microscopically that has nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by somebody who actually knows what they're doing. And my problem with Mr. Lally response, and I understand why he's responding this way. Well, there was no deception here. We weren't pulling the wool over the court's eyes or counsel's eyes or anybody else's eyes. It looked like a hair. Why didn't they say that? Why didn't they say it looks like a hair as established by our expert who failed her proficiency examination? That would have been a truthful statement. But the statement that they've repeated over and over and over to this court in papers
Because
and in
state is
affidavits under oath
asshole.
under penalty of perjury is the hair has been forensically confirmed. There is no, you can't word salad your way out of that. Forensically confirmed means it's been DNA tested to confirm forensically and scientifically that it is a hair. Then they turn around and try to confirm it forensically, and there is no human DNA detected. I understand that the short tandem repeat testing, the mitochondrial testing, has not been done yet. That's their 11th hour sort of Hail Mary to try to cover themselves for what they've already done, which is to basically defraud the court in not one, but two, but three, but four different filings. 3 in front of this court, 1 in front of the Court of Appeal. It just doesn't pass the smell test. What we're asking for is very simple. We can address the mitochondrial destructive and exhaustive DNA testing at some point down the road. We want access to that item so that we can confirm whether or not it's even microscopically been properly analyzed. That's all we're asking. And I'll submit.
Can you get me an affidavit from your expert as to why photographs are not sufficient?
I can, and I can, as an officer of the court, I can certainly indicate to the court that this has been done enough. I'm experienced enough to know that they can't do
Welcome
it
back,
even
Jimmy the Witch.
even a micro photograph. They have to see the item in person, but I can get a declaration to that effect.
And how the procedure would be conducted and how long it might take? Put all of that in writing for me and I'll consider it when I consider this motion.
Thank you, Your Honor.
All right. So we'll move on to Mr. Yannetti's motion
Now
as to
this is
why I should change the
this is
conditions of release.
Thank you,
this
Your
is
Honor.
where it gets all the spices. So gather around, people, gather around, because this is
Please,
where
the
it
court, I
becomes.
appreciate the opportunity to be heard. Your Honor, I stand before you because it is in the interest of justice for this court to lower my client's bail to personal recognizance in exchange for Ms. Reed turning in her passport and signing a waiver of rendition. We make this request because there are numerous important changed circumstances that have come to light since bail was last considered and modified. We also make this request because my client's finances continue to be drained and depleted as she struggles to pay the multiple experts she needs to properly defend herself in this case.
So before we go any further, I saved this motion to the end because you indicated that I would have an affidavit from your client as to her finances. I do not have that,
Yes, I did not file that electronically. I had told your clerk.
but I still don't have it now.
I have it in my hand, Your Honor.
So that doesn't help, does it, Mr. Yannetti? I need to read it.
No, I'm happy to pass it up. These
So
are-
just give it to me and let me read it.
I just need to clarify, these are expenses since the last bail hearing.
All right, so give me a minute before I hear you on
Yes.
this. Has the Commonwealth seen this?
I'm filing it at ex parte.
So no, I have not.
Well, do we really need you to see anything, Mr. Worm? We'll give it to you when we're done with exhaustive testing. I mean, when our experts feel fit to give it to you, we could give, we'll just take our time too. Yeah. I mean, I do get the point that he should have had the affidavit, electronically filed, so she could have looked at this and had that, at the ready. But the state seems to be dragging ass on every single daggone thing. And she's like, "Okay, that'll be good. We'll put a recess in for another
All right, so Mr.
870
Lally,
days."
Mr. Yannetti, you've seen, I imagine, in your time as a prosecutor too, you've seen affidavits of indigency.
Yes.
This doesn't give me enough information.
Well.
Doesn't give me enough information under Brangan, doesn't give me enough information at all.
My client has expended multiple, fees to not only experts, but also to lawyers prior to the last date as well, Your Honor. In terms of qualifying as indigent, I would argue that we have a little bit of a different situation here. Generally speaking, somebody qualifies as indigent because they can't afford an attorney, they can't afford any experts at all. That's not what we're saying. What we're saying is there's an overwhelming financial crush with regard to this particular case. And there are also, I should say, many, many more expenses to come, many of which have been already discussed by this court with regard to the multiple experts.
Do you want the opportunity to file a proper affidavit under Brangan? This doesn't give me the information that you know that.
We're happy to do that, Your Honor. I would still like to make my argument today.
Okay, you can make I can't make the findings under Brangan,
Right,
Mr.
well,
Yannetti.
but at the end of the day, Your Honor, if it's supplemented by an affidavit, then the court can make a finding at that point.
Okay, I'll hear you since you're here and you're ready, and we're doing a great job with timing. I appreciate counsel all being
Thank you.
succinct
I
today.
appreciate that, Your Honor. As just continuing with my train of thought, the $80,000, our argument is, it's sitting in the Norfolk Superior Court Clerk's office now, serving no purpose other than to prohibit my client from using that money to properly defend herself. Your Honor, every time this bail has been discussed regarding this matter, both in Stoughton District Court and in this court, the Commonwealth has consistently maintained that their only justifications for requesting bail are, number one, the potential penalty my client faces, and number two, the nature and circumstances of the case. With regard to with regard to both, I'm concentrating my argument on changed circumstances. with regard to the potential penalty in light of the changed circumstances that have and will be discussed during this argument, in light of what we've learned since the last time bail was modified, we believe, and my client well knows, the potential penalty she faces is nothing. There will be no penalty here because there will be no conviction. There will be no conviction because the evidence establishes her innocence. There is no jury anywhere who will ever vote to convict her for a crime she did not commit. And that leaves us, Your Honor, with a bail argument that relies really exclusively on the nature and circumstances of the case. And the nature and circumstances of the case, as represented by the Commonwealth during its numerous bail arguments regarding this matter, have been shown to be false. It is a fact that the nature and circumstances of this case have completely changed, even since the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor, having read only the scant information that the Commonwealth made available to me, it was still immediately clear to me that this case was a tragedy but not a crime. From the very start, with most of the evidence hidden from the defense, the Commonwealth's case against Karen Reed was extremely thin. And from the start, she had no reason to flee, because even without the results of our investigation, her defense was strong. And it was strong because it was based on innocence. By the time I got back to my office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime. But shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie. Rather than take Michael Proctor's word, we instead said our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street. Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th. And when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there. And Mr. Laughlin was firm with Trooper Proctor. There was no body. And he told him not only was there no body, but if
He's
there had
definitely
been a
my
body
kid,
there, he
I
would have seen it.
swear. He's a
He left
griffin.
Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case. To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting her. No body at 2:30 a.m., she is innocent. But Your Honor, it's not just that he saw no body at 2:30 a.m. After that, he saw a Ford Edge parked right in the area where John O'Keefe's body was later found. Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons know or knows exactly what happened to John O'Keefe. That mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe, and that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail. Frankly, when the Commonwealth relies on the nature and circumstances of the case in order to justify bail being set, those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in
Why are
part
you surprised?
on a
They have
representation by Mr. Lally at my
shown
client's
themselves to be
arraignment that
douches
there was that
through
apparent
and through.
hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed her proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer McCabe, who had been at Brian Albert's house on the night in question and would have had to walk by John O'Keefe's body in the yard if it actually was there at that time, went home and at 2:27 a.m. Googled "Hosslong to die in cold." You did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert not only found that search, but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert is certain. And importantly, the Commonwealth's handpicked expert, Ms. Hyde, confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it goes without saying, Your Honor, that Jennifer McCabe's Google search, trying to determine just how much time had to pass before John O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that a human hair was found on my client's car when it wasn't, but importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and reveal that Chloe attacked not just one, but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case, that information was kept from you. It is now yet another change circumstance that justifies the lowering of Ms. Reed's bail.
Of course it
Now,
is.
I expect that the Commonwealth will argue 2 points in opposing this motion, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and 2, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle. He was in the vehicle that night, shortly before he was killed. He was around the outside of the vehicle several times that day and night. That vehicle was parked at his house for months. He lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m., a Ford Edge being near the yard where the body was later found after 2:30 a.m. Give Jennifer McCabe Googling how long to die in cold at 2:27 a.m. and then 3 minutes later, Brian Laughlin driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail argument? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the
So
appropriate time.
I don't need to see a chalk, Mr. Yannetti. You didn't give me sufficient evidence under Commonwealth versus Brangan.
Well,
So I will hear you because you want to make this statement. So go ahead, but no chalks.
You're right, just so we're clear, it's not just her financial status that justifies reducing the bail. The thrust of my argument is all with regard to changed circumstances.
I understand that, so I'm going to let you continue. But a very important piece of this is missing. So go ahead with your argument. No chalks, please.
Yeah, and obviously my argument is, leaving the financial issues aside, the bail should be lowered based on my argument here
And a chalk is a demonstrative or a display. I looked it up the last time we were watching it because I did not know what a chalk was.
today.
There's
that
your
I'm making to this
entertainment for
court.
today.
I had just stated, Your Honor, that in order for the microscopic supposed pieces of taillight to have any evidentiary value, you have to trust who had custody of them, which means that you have to trust Michael Proctor. And I question, how on earth can anyone trust Michael Proctor? I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by taking the case. The more appropriate word to describe him is corrupt. Only a corrupt state trooper would agree to investigate a murder case in which a body was found in the yard of a family friend. Only a corrupt state trooper would keep his ties to that family friend hidden. Only a corrupt state trooper would refuse to go inside the home, which featured the body of a dead police officer on its lawn. Only a corrupt state trooper would write in his report that a street had not been plowed when it had. It was the corrupt Michael Proctor who took custody of John O'Keefe's clothing, and that clothing was not submitted to the lab until several weeks after Michael Proctor seized it. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet, you see a pile of John O'Keefe's clothing, unattended, sloppily thrown on the floor. That's the care with which Michael Proctor treated what they now claim is important evidence. And that clothing was not submitted to the lab, Your Honor, until after Michael Proctor had seized my client's Lexus, and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of not sending it to the lab until March of 2022. He had it for weeks. Michael Proctor's mother has described the Albert family as the Proctor's second family. Michael Proctor told witnesses who showed up to testify before the grand jury that Brian Albert is the salt of the earth. Michael Proctor's wife has posted about how much they love Colin Albert. The Proctors have constantly been photographed with the Alberts going back over a decade. We've shown that Michael Proctor's in a wedding party with Colin Albert. Colin Albert was the ring bearer at Michael Proctor's sister's wedding. It's so clear that Michael Proctor was both conflicted and corrupt. He had every reason to sprinkle tiny pieces of taillight that he had seized into the clothing that he alone took, so that the lab would later find it weeks later, and sure enough, they did. And this supposed discovery does not undercut the fact that Jennifer McCabe Googled how long to die in the cold at 2:27 a.m. and Brian Laughlin went by and saw no body outside that house 3 minutes later. So legally, you have all the support you need to release my client on personal recognizance. There's also a practical side to this, which gets into the financial issues, Your Honor, and I'm almost concluding my argument here. You've seen my client's medical expenses in the past. You've been aware of her loss of income. You've also been aware of the numerous experts, witnesses, investigators we've had to retain to do the job that the Commonwealth either failed or refused to do. Those expenses continue to mount. She has not asked this court for a dime to pay for any of those expenses. We're now approaching a trial date, which we will request today. Those expenses continue to mount and indeed will skyrocket. She cannot afford to skimp on these experts. The stakes are too high. She needs every dollar she can to keep going, and $80,000 is a lot of money that would go a long way toward supporting her defense. To make it clear, Your Honor, we are not making this request without offering something in return.
Awesome. Thank
I would
you.
submit there's nobody in this courtroom who believes my client is a flight risk. Given the national publicity that this case has generated, which I submit will only intensify as we approach a trial date, my client is one of the most recognizable criminal defendants in America. Where on earth would she go, even if she wanted to go somewhere? But she's not going anywhere. Her family's here, her doctors are here, and given the strength of her defense, as illustrated by the changed circumstances we've discussed, she has every incentive to fight this case and no incentive to flee. She's made every court appearance and has invested herself 100% into this case, financially, emotionally, and intellectually. But if there's any concern at all, Your Honor, my client will dispel those concerns by turning in her passport. I have it. She's ready to give this to the probation department. She's ready to sign a waiver of rendition, any waiver of rendition the court would desire.
Thank you,
So on
Bobby,
this
and
issue,
thank you,
she's really
Shenanigans, and
figuratively
everyone
putting her
who's
money where her
watching.
mouth
Thank
is.
you so much. You
Giving her
guys are really
passport and a
awesome,
waiver of
and
rendition is far more valuable to this court
stop
in
talking.
terms of assuring her appearance in court than $80,000 is. But that $80,000 is more valuable to her because she desperately needs it to defend herself. So for these reasons, Your Honor, I ask that you help us to level the playing field here. The Commonwealth has unlimited resources. My client does not. I ask that you release her on recognizance and give her the tools she needs to fight this case.
All right, thank you.
Hello,
Do you want time to provide that affidavit to me?
I'd be happy to do that, Your Honor.
How quickly can you do it?
We have 1 week.
Okay,
Thank you.
yes. Mr. Lally?
Just very briefly, Your Honor.
This is where the crowd goes nuts, but not for him, obviously.
Commonwealth just requests that the bail remain the same. There's no change in circumstances of the facts, and I use that term loosely as Mr. Yannetti was recounting for the court. Notably absent from his motion in regard to the apparent hair, which I've gone into great detail to explain. I won't bore the court with that explanation again. But what it leaves out is, again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of
Thank
which
you.
being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as what counsel states as Mr. Loughran's testimony goes into a great detail in the motion as well. What he leaves out, though, is that all these insinuations.
Oh, I thought
that
you were
the
talking
Ford
about
Edge somehow
the,
belongs to the Alberts, or Ryan Alberts Ford
thought you were
Edge, or
talking about the
something to that
prosecutor,
effect.
so
What he leaves
that
out
works.
from that interview with Mr. Loughran is that Mr. Loughran specifically says that Ford Edge is not Brian Albert's Ford Edge. Another sort of interesting issue in relation to the affidavit from the investigator in regard to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Loughran out to the parking lot, points to a Ford Edge, and essentially says, "Is that it?" somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence.
Turtle boy.
I guess now it's being positioned that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than 1/16 of an inch that were embedded within Mr. O'Keefe's clothing. I'm not going to go over again and again the issue as far as Ms. McCabe's search on her phone. The court has been provided numerous reports from forensic experts disputing whatever Mr. Green's findings are. Counsel seems to want to choose or pick and choose as they do with each particular piece of evidence or each report as to what they want to highlight. But the conclusions from Ms. Hyde's report are clear, that from her analysis of that search was conducted respectively at 6:23 a.m. and 6:24 a.m. It is not a mystery as to when that search was conducted or why that search was conducted. It was conducted by Ms. McCabe at the bequest of the defendant. As far as anything pertaining to Ms. Reed's financial resources, again, those were filed ex parte and as the court, so I really can't speak to those. All I can speak to as far as financial resources is this case was initially arraigned in the Stoughton District Court. The court set a cash bail of $50,000. The defendant posted that within minutes. The defendant was then arraigned in this court. The court set a cash bail of $100,000 initially at arraignment in June of 2022. That bail was posted within minutes. If the court is inclined to reduce the cash bail, I don't think it's of much moment to the defendant, Ms. Reed. But if it were, I would ask that some additional conditions be set in place, similar to what I had asked for previously on the February date. If the court were inclined, I would concur with surrendering a passport. I would concur with executing a waiver of rendition, and I would ask that there be an additional order the defendant be ordered to remain alcohol-free, subject to random testing with a SCRAM device, based on the nature and circumstances and based on the indictment she faces in this court. Thank you.
Okay,
If I may respond briefly to 2 points, Judge.
okay.
And this is where he goes boom with the microphone.
Your Honor, first, with regard to the DNA being a match or a presumed match of John O'Keefe, what Mr. Lally didn't tell you is that that sample was a mixture of John O'Keefe and 2 unknown people. So I don't know if the Commonwealth is changing its theory again to say that my client struck John O'Keefe and 2 other people and the other 2 people somehow got away, but that doesn't make a whole lot of sense. The second thing is, with regard to the Ford Edge that Brian Laughlin saw outside that property, I would say 2 things. Number one, assume it was not Brian Albert's Ford Edge. It doesn't matter because there was somebody there outside the property where the body was found after 2:30 a.m. They would have either seen or not seen a body and known or not known that there was a body there. But finally, with regard to that point, Mr. Laughlin was clear that it was not Brian Albert's Ford Edge. What he did not tell you, what Mr. Lally did not tell you is there's another member of the Albert family that has a Ford Edge, and that's Colin Albert.
Boom.
Okay.
And Hollywood writers, this is how you write a court procedural. You're welcome.
So, Ms. Giannetti, I need that affidavit by next Friday, so I'll take this motion
Thank you,
under
Your Honor.
advisement.
Appreciate it.
All right, so I said at the beginning that we need to set dates. And it's been mentioned that there have been a couple of pretrial conference dates. There have, but counsel have not complied with the Superior Court standing order that we need to get back on track. So Superior Court standing order 2-86. So we need to set some dates. And counsel has to comply with Rule 11 of the Mass Rules of Criminal Procedure regarding the pretrial conference. So I'm going to give you a date for you to fill out the pretrial conference report and do everything that you're supposed to do pursuant to Rule 11. We need that before we can go any further. And in that report, you need to outline dates for filing of motions. So I have some suggested dates, given that we were able to work out the discovery issues today. So I think all non-evidentiary motions in this case must be filed by November 16th. I don't want any more piecemeal Rule 17 motions. If there are piecemeal Rule 17 motions, you need to put in the affidavit why those weren't handled when they're supposed to be. I would like January 5th for filing all evidentiary motions. And February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Your Honor, it would be the defense request, and we're open to the specific date, but we would like a trial date in March 2024.
Okay, that's great.
Early March would be better if it's available.
So we have a trial that's starting in January, a retrial that last time took 6 weeks. So I think mid-March would be better for us.
Okay.
Jim, can you suggest dates?
Yeah, how is March 12th? 12 or 19?
12 would work.
Is the court's preference, just going by what Mr. Tony said, start on Tuesday?
Yes, we typically do Tuesday.
Yeah, because civil and panels on Mondays.
Makes perfect sense.
Yeah.
Does that work for the Commonwealth as well, March
March
12th?
12, yes.
That's
So,
fine, Your
as a result of that, can we have a final pretrial conference sometime the end of February?
Now you put them
Maybe.
on close up.
26,
You
27,
rat
28?
bastards.
in that
I had wanted a
timeframe?
close up the entire time.
Is that okay?
How did
Is that
Hank Hill
weekend?
get in there?
We're just
Oh, I'm
checking,
sorry,
yeah.
I'm sorry. Yeah, yeah, go
It's,
ahead.
it's good for me. I just want to make sure it's good for my.
Yeah, yeah,
co-counsel.
fine.
Also, how did this guy escape from Miami Vice?
We do the 26th. Would that be available?
That's a Monday, we can do that.
Is that-
That'll be at 2
I
PM.
was just going to ask. All right,
Yeah, and we expect you to exchange motions and eliminate any potential voir dire questions, as whether or not you want to do a panel voir dire.
Great.
So that we can talk about it on the,
So those, and the dates that I gave you, November 16th and January 5th, those are out-of-court dates. Have all your motions filed on those dates. And give me a realistic date that you all can file your pretrial conference report. I suggest it be around November 3rd. Maybe we'll do November 3rd. Does November 3rd actually work?
can you do November 3rd?
Yeah, November 3rd is fine. Judge.
So
All right.
there's obviously
That's just the final
factions.
conference and that's on.
Yes. So we currently do not have an in-person date until we see about those filing of motions from January 5th.
Does it make sense to have an in-person date of November 3rd, Your Honor?
It does if you want, but you've talked about the expenses. It doesn't make any sense to fly people out here if it's unnecessary.
My suggestion, my suggestion is that the Jesus will we would like to have a person hearing on November 3rd. just to
Okay.
make sure that there's any T's that need to be crossed, or I's that need to be dotted.
I'm not available that day,
Okay?
that week, actually.
That whole week.
I'm on trial.
Can we pick a date the next week? 6, 7, 8, or 10?
10, it says Veterans Day observed, but I don't know. No, Jim, let's actually do the following week. Let's do the 16th.
So. November 16th, can you do November 16th?
And I'm sorry, that's for what event?
This next in court date, we can't do the 3rd.
Oh, you can't do the
Yeah,
3rd. I'm
yeah,
sorry.
no,
Okay.
the 16th.
That's the date that you're to file all non-evidentiary motions by anyway.
Yeah.
Yeah. Yeah, I was gonna say something about the duck lips. I don't quite get it.
Jim,
My counsel makes a good point. Maybe, oh, I'm sorry.
oh no. We can't, I don't want to use that week.
Yeah,
Go ahead. I was gonna say, Your Honor, it may make sense to do it maybe a couple of
Okay.
weeks later after we've filed all the non-evidentiary motions. Could we potentially do December 1?
No, that's the Superior Court judge's business meeting.
I see.
You can do the following week. You can do the 8th if you want a Friday.
following week, the week of December 4th.
Let's do the 8th, Jim.
The
Friday?
8th, can you do the 8th of December?
Yeah, the 8th works. It's fine.
Is that okay? 12/8 is the next in-court date.
Do
Um,
9 o'clock, Jim.
9 o'clock, okay? Everybody? Good. 9 a.m. Thank you.
Thanks very much, Your Honor.
So
Take
12,
this,
8, 9 a.m.
All right. Jim, I'm going to keep everything with me.
Okay.
Goodbye.
Okay.
That'd be great.
All right. So that was that. And let me see if I can pull up. Finally, they have put up. Okay. Stop you, start you, and we'll get some of Gareth done. Yeah, I will tell you to go to Turtle Boy. He has done yeoman's work. I have no idea what's going on, which is not all that shocking. Let's make sure I have the right day here. Isn't that yesterday? This is yesterday, isn't it?
President, including the alternates, all council. President, including the alternates, all council present, defendant as well. We're going to continue with Officer Fizek, whose testimony we interrupted. You can take the stand if you would, Officer. Reminder, you're still under oath. But before I do that, let me read a stipulation to you. You can actually. And I explained last time what a stipulation is. Do you all remember that? The stipulation is an agreement between counsel or among counsel regarding a fact or set of facts as having been proven by the evidence, and you're to accept them as such, all right? The stipulation reads as follows. Evidence of Amy Harwick's state of mind regarding her
Yes,
fear
this is
of
yesterday. These people are trying to chafe my something or other unmentionables. All right, now we've got the right one. I'm going to do actually, I'm going to start this, and I can still hear it, but I'm gonna run Frybert out.
an admonishment by the court, and it read as follows. Evidence of Amy Harwick's state of mind regarding her fear of the defendant Gareth Pursehouse has been admitted via Amy Harwick's email to herself and statements to friends for the limited purpose to show that she would not have consented to him entering her home, would not have
But
consented
that
to
way,
him
I'm gonna
lying
let him out
awake.
so I don't get puddles on
You
the
may
floor.
consider that
Real
evidence
quick.
only for
I'll
that
be right
purpose and
back.
for no other. But no, you may consider that evidence, I neglected to state, with respect to her state of mind of being in fear. Okay, there you go. All right, you may call your next witness.
Thank you, Your Honor. The people call Angeli G.
The first initial of last name is G, is that correct?
Correct, Your Honor.
Okay. If you could raise your right hand, face my clerk, please.
Do you solemnly state that the testimony you're about to give and the cause now pending before this court should be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. Please have a seat. Please state and spell your first name.
Angeli, G. Angeli.
Okay, first initial of your last name is G.
Yes.
I'm going to ask you to lean right into the microphone so everybody
Yes.
can hear you. All right, Counsel.
Thank you, Your Honor. Good morning.
Morning.
Do you know someone by the name of Gareth Pursehouse?
Yes.
Do you see him in court today?
Yes.
Could you please identify him by telling us where he's seated and what he's wearing?
Over there, he's in a suit.
Could you describe the color and shirt?
Looks blue and blue.
Blue and blue what? Blue shirt and,
Blue blazer, blue shirt.
okay, identify the defendant.
When did you first meet the defendant?
About 2 or 3 weeks before Valentine's Day, 2020.
And how did you meet him?
On Tinder.
And for people that don't know, what is Tinder?
It's a dating app.
And you met each other on the actual application?
Yes.
Did you communicate with each other using the Tinder app itself?
For a brief period of time.
Soon thereafter, did you continue your communication via cell phone?
Yes.
In order to do that, do you actually have to exchange phone numbers with a person?
Yes.
I'm sorry?
Yes.
And did you actually exchange phone numbers with the defendant?
Yes.
Did you store him in your cell phone number under his name and phone number?
Yes, ma'am.
Now, when you started to communicate outside of the Tinder application, did you exchange text messages?
Yes.
Did you exchange phone calls?
Yes.
How often would you say you communicated in the 2 weeks prior to Valentine's Day of 2020?
At least once a day.
Can you all hear? No. Okay, you're going to have to.
Sorry.
Speak a little louder if you can, please.
And that could move a little bit too if you wanted to.
No, scoot up. Is that better?
Yes.
Yeah, that.
I'll ask again.
Okay.
Actually, I don't remember my question.
Can you read it back now? Thank you.
Question, how often would you say you communicated in the 2 weeks prior to Valentine's Day of 2020? And your answer was, at least once a day.
When you say once a day, would that be either by text message or phone call?
Sure.
Now, when did you finally see each other in person after first meeting on the application?
Maybe a couple days after meeting on the application.
In the 2 weeks leading up to Valentine's Day of 2020, how often had you seen each other in person?
2 to 4 times.
2 to 4 times?
Yeah.
Now, I know this is an embarrassing question, but I have to ask, were you intimate during any of those meetings that you had with the defendant those 2 to 4 times?
Yes.
Now, I
We've
want
had
to turn
all
your
the
attention
sexy
to
times.
Valentine's Day itself, February 14th of
He wasn't
2020.
creepy then.
Did you guys actually communicate on that day?
Yes.
Was that via phone call or text message?
I think it
Thanks,
was
guys.
text.
At this time, Your Honor, the people are holding a series of text messages. It's one page made out in marks.
Look, it was Valentine's Day desperation. That's a no. Put the yarn down.
Showing you what's been marked as people 68. Do you recognize these series of text messages?
Yes.
Do you recognize these as the text messages you exchanged with the defendant?
Yes.
Now, I'm turning your attention to a text message that's in green. Are those text messages that you sent or text messages that you received?
I sent those.
And the text messages that have a dark background, what appears to be a dark gray or black background, are those text messages that you received from the defendant?
Correct.
Now I'm pointing your attention to the text message in green where it says, "What are you up to and why haven't you asked me out tonight? Sad face." Is that a text message that you sent to the defendant on Valentine's Day?
Yes.
And did he respond to you shortly thereafter?
Yes.
Now, what time was that?
Looks like about 7 p.m.
Can you see it better there?
6:48 p.m. It says.
And what was his response to you?
En route home, I told you I'm busy all week.
He's like, I'm
Now,
stabulating
Do you
someone.
expect to hang out with him that day?
I did.
And why did you expect to hang out with him on Valentine's Day?
We had been hanging out, and I enjoyed his company.
Now, did you find it kind of annoying that his response to you about Valentine's Day was that he'd be busy all week?
Yes.
Did he actually tell you what he was doing that day?
He said he was working on projects with some friends.
Did you find that to be a good excuse to not go out for Valentine's Day together?
Not particularly, but it is what it is.
Now, did you exchange text messages the next day, February 15th, 2020?
Yes.
Now, I'm showing you another series
Now,
of text.
the real crime that all is that all of these people are forgetting the real holiday, which is the day after Valentine's Day, when all of the good chocolate goes on sale 50% off. Duh. All right, we shall
Of
continue.
text
I mean,
messages.
other than the real crime,
When was
which
your
we all
first
know.
communication the next day?
10:59 a.m.
And what was that communication?
He texted me, "Morning sunshine." I said, "Hi." He said, "What are you up to?"
Now, Morning Sunshine, was that the first communication you and the defendant had on February 15th?
Yes.
So he initiated that communication with you.
Did you know?
Correct.
Not the
Now, in response to the defendant's asking you, what are you up to? There was a series of text messages here. Just got back from walking dogs. Think I'm gonna ride my bike to the beach in a bit. It's gorgeous out. Oh, and getting quotes for a trip. Is that your response to the defendant?
Yes.
What do you mean when you say, oh, and getting quotes for a trip?
I was looking into how much a trip would cost.
What kind of, like a trip?
Out of like a vacation.
Oh, I'm sorry.
Relevant to anything?
Well, let me ask you this, and the reasons for those questions is a segue into this. Did you end up seeing the defendant that day?
Yes.
And
Like
how
licorice
did you
is
go about
gross.
meeting up with the defendant on February 15th, 2020?
I rode my bike
No, right.
on the beach, and I stopped by his place.
And how did you go about getting a bike to ride over to the defendant's place?
I got a jump bike, which is an electronic bike that you can rent.
Now, when you talk about a jump bike, is that one of those ride share bikes that you see on the side of the road that you
Yes.
use your phone to ride?
Correct.
And when you do that, you utilize your cell phone. Is that correct?
Correct.
And you receive.
Again, how is any of this questioning relevant? I get that they have to, how you get to point A to point B, but like, so did you have smexy times? Yes, it was regretful. I'm embarrassed. Do we have to talk about this? So you drove an electric bike, which kind of negates the whole like I'm trying to be healthy thing. Okay, yeah. Did you still wear yoga pants and athleisure wear? Yes. Okay. All right, good. Did you wear Lululemon? All right, good. You paid $300 for a pair of pants. Awesome. Can we get to the point? When did you find out he
Counsel,
done
relate a
killed
foundation
his
for something?
ex?
Yes.
Okay.
I mean,
I'll give you some leeway.
allegedly.
Thank you. And do you receive a receipt as a result of that ride?
Yes, you do.
Your Honor, at this time, the people are holding a receipt of a trip. May that be marked as People 69?
Yes.
They have receipts. If this isn't exhibit 100 for
Showing you
100%
what's
correct,
Showing you what's been marked as People 69. Do you recognize what's photographed here?
Yes.
And how do you recognize that?
That's the route I took to get to his place. It's along the boardwalk.
So is this receipt reflect your trip from your house to the defendant's house?
Correct.
And he lives in what city?
Playa del Rey. I believe.
I'm going to zoom in here just a little bit. Where my finger is pointed indicates Saturday, February 15th, by 29768, 12:29 to 1:40 p.m. Did you arrive at the defendant's house at 1:40 p.m. as reflected in this receipt?
Objection waiting.
Go ahead, sustain, ask your next question.
I
Can
don't
you
know
describe
why
the
this
time
made my
frame that's
Friday, but it really did.
explain the time frame that's depicted in People 69?
I arrived at his house at 1:40 p.m.
And what does 12:29 signify?
The time I left my house.
So it took you approximately 72 minutes to get from your house in where was that?
Santa Monica.
To Playa del Rey?
Correct.
Now, what did you do once you arrived at the defendant's house at around 1:40 p.m.?
He greeted me. We went up to his place, and he was doing some work on the French doors at the front of his place, and I helped him organize his apartment.
How long would you say you...
Wait a minute, you were doing girlfriend tasks and you were still in the talking to stage? Oh, no, ma'am. No, ma'am. Until you get a commitment, you do not do housework.
were in his apartment for that evening or that day?
Maybe 2 hours.
And what would you say his demeanor was when you initially saw him?
He greeted me, and after that, he seemed sad and distant, I'd say.
Now,
I'm sorry, I could not hear.
You seem sad and
Distant.
distant.
were you
Just, like,
intimate on
in
this
your ear.
occasion when you went to the defendant's house?
No, ma'am.
Did you guys hug or kiss?
I think we hugged, but that's it.
You may have kissed, or you unsure?
Maybe.
Was that something that you would have customarily done in the prior times?
It's this thing. Sorry, Cancel.
Yeah, no kissing talk.
Now, you said you hung out in the defendant's house for about a couple of hours. Is that correct?
Yes.
Did you guys decide to do anything else aside from just stay at his place?
No.
Was there any conversation about doing anything else aside from helping him organize his house?
At that point, no.
At what point did you guys discuss doing anything else aside from staying home?
Prior to my riding the bike along the boardwalk, we discussed what if we wanted to hang out today and what we would do.
Was this on a phone call?
Correct.
And what was the discussion in regards to what to do that day?
I think we threw out ideas. I don't recall exactly, but I think he suggested maybe going to the shooting range. I wanted to go to the beach
Oh.
because it was a beautiful day out and I wanted to be outside. He said he couldn't go in the sun because his skin was sensitive.
He couldn't go in the sun because he was going to get arrested.
Because I'm sorry, what?
He said his skin was sensitive, so he couldn't be outside. And I think he suggested going to the shooting range after that. And that's, I think, when I said, I'll just ride my bike up to you and teach you how to use the jump bike, because he'd never ridden one before.
Now, while you were hanging out with the defendant in his apartment, did you notice any injuries to him?
Yes.
And what kind of injury did you notice?
There was a bruise under his eye and maybe some scratches on his face.
Did you...
I didn't get that either.
Bruise under his eye and scratches on his face.
Okay.
Your honorship, get some new goddamn microphones in. Look, sir, you done screwed with all the microphones because you have a cool one, but it's time to stop lowering the volume on all of them, okay? And Bobby, I do feel bad for her. I mean, you try to go date, you meet a guy who seems like he's relatively normal, which I'm sure in California and in this current dating climate is a bajillion and 12 times more difficult than dating ever. And, you know, you find out he's done allegedly offed his ex, and he could be using you as an alibi. And then he wants to take you to a shooting range because his skin would get... Ma'am, I am clear see-through and I still go out in the sun area. This man is at least 2 shades darker than me. His sensitive skin, my ass. Yeah, you don't start doing girlfriend stuff for a man that isn't doing boyfriend stuff for you. No, ma'am, you do not clean. We're gonna have to have a we're gonna have to have a whiteboard of truth.
On his face.
So just to, so that people can hear you, why don't we try to maybe keep your voice up just a tiny bit?
Sure.
Thank you. You said you noticed a bruise and some scratches. Do you know which eye?
I think it was his right eye. He had
Is
a
that-
bruise.
I'm sorry, is that to the best of your recollection as you sit here today?
Correct.
Did you ask him about how he got this bruise and on his eye?
I did.
And what was his response?
I believe he said he cut himself shaving.
Did you find that response to be odd?
His eyeball?
All right, sustained.
Did you believe him?
Objection irrelevant.
Sustained.
So his response to you asking him about a bruise under his eye was that he cut himself shaving.
Objection has an answer.
Well, overruled, because there were two injuries, types of injuries noted. One was
Was he going full Pink Floyd and trying to shave his damn eyebrows off? The hell? Dude, you bombed your freaking stand-up thing. You think you could have thought in like all the 10 seconds, the day and a half of freedom you had, I was shaving, like walked into a damn doorknob for the love. Hurt myself shaving.
one was scratches to his face, the other one was the eye bruise. So you can ask the question. Once you ask, we ask it again.
Go ahead and
I'm sorry, what was the question again?
MMA
so
fighting.
his response,
Fight
you
Club,
asked
I
him
mean,
about how he received a bruise on his eye was that he cut himself shaving.
Correct.
When you say there was a bruise on his eye, did it appear to be a black eye? What kind of bruise?
It looked like a small black eye. Correct.
Had you seen a black eye on him prior to that day?
No.
Now, I know you said you hung out with him at his place for a couple of hours. At any point during the time you were with him, did he ever mention that he ran into an ex-girlfriend recently?
No.
Did he mention to you that he actually went to his ex-girlfriend's house on Valentine's Day?
No.
Did he appear distraught to you when he was hanging out with you?
Well, she said appear as opposed to wasn't distraught all along.
No.
In any of the times that you hung out, did he ever mention running into his ex-girlfriend?
No.
Did he indicate any thoughts to you on February 15th when you were hanging out at his house that he was very depressed?
No.
Did he indicate to you that he was at all suicidal while you were hanging out with him?
No.
Did he ever, in the time that he spent with you, express that he was suicidal?
No.
look, you can fake not crazy. You can pretend to be a cool person for about 2 weeks, and then about 2 months in, people start to realize some cracks. Well, yeah, he needed her to be his alibi and or his next victim. He was taking her to the shooting range. I mean, sir, you're supposed to time these things out for a little bit. Groom her as your next girlfriend slash victim for a little bit. I mean, you're escalating rather quickly here.
Thank you. No further questions. Sir.
Cross-examination.
Your Honor, I actually have a couple of other questions. May I reopen for just a moment?
Yes, go ahead.
Sorry. Prior to testifying today, you had a conversation with me today. Is that correct?
Yes.
Did you also have a conversation with defense prior to your testimony today?
Yes,
And when was that?
a few weeks ago.
And during your conversation with defense a few weeks ago, were you asked certain questions in regards to your interaction with the defendant on February 15th, 2020?
Yes.
What sort of question was asked of you in regards to what you guys did together on February 15th, 2020? Now, in regards to your activities with the defendant on February 15th, 2020, you gave a statement to detectives. Is that correct?
Yes.
And you gave this statement to detectives around the time the defendant was arrested. Is that right?
Yes.
Were you with the defendant when he was actually arrested?
Yes.
Where were you guys going?
He was dropping me off at my house.
And during that conversation with detectives, you indicated to them what you did with the defendant while you guys were hanging out. Is that right?
Correct.
Was that same sort of question asked from you by the defense?
Yes.
Did the defense bring up with you that?
It's not a questioning, Your Honor.
Well, I have heard the question.
It is again going into what the defense asked.
Let me hear the question.
Was there any questioning that was initiated by the defense in regards to the defendant asking you to go to a shooting range?
All right. Sustained.
Withdrawn. Nothing further, Your Honor.
All right.
And that question is strict and serious disregard.
Yes.
That.
So most SSRIs, you can look at them. What you want to look for if you do have to go on an antidepressant, and this is not technically medical advice, but a weight neutral or medication, because there are some that are notorious for weight gain, but you want to look for a weight neutral SSRI if you do have to be put on, if that is something that you are worried about. There are some that have been found generally effective if you believe in antidepressants that are weight neutral. Yeah, look, like I said, I don't promote fluffy on fluffy crime. I am trying to be a little bit healthier and make healthier choices, but you can choose ones that have less of a propensity to cause those kind of side effects. But being in prison, I don't know that he has chances to choose, if you will. Oh God, it's Helen Lovejoy. That binder is so messy. It irritates me. Ma'am, could you not have had this all put together? It's not like she had extra time to do questions.
Okay.
No, please take 3 extra minutes to get all your sticky notes
All
together.
right. So I wanted to start by asking you when the first time was that you met Gareth?
It was a few weeks prior to February 15th, 2020.
Do you remember the date?
No.
Okay. And when you met him, what did you guys do?
We went to a comedy club.
Oh, dude.
And was this for a friend's birthday?
Correct, yeah.
Do you remember who?
Was she the hot chick that saw him bomb on his comedy hour and she still slept with him, allegedly? Because, dear Jesus, this woman has a heart of gold.
You remember who that friend was?
No.
Does the name Corey Soria sound familiar?
Sorry, no.
Okay. And that was at the, which comedy club was it?
The Comedy Store or the Laugh Factory? I can't recall
One of
which
those
one.
two?
Yeah.
Okay. And did you both arrive late and then leave early?
I don't recall arriving late or leaving early.
Okay. You just arrived whenever and
Yeah.
left whenever.
Yeah.
And do you know approximately the date you first started interacting with Gareth?
Again, a few weeks prior to February 15th.
Okay. So on February 15th, you got this text message, morning sunshine, and you decide to take your jump bike and ride to Gareth's apartment. Is that right?
Yes.
And how many times had you been to that apartment?
I think twice before.
Okay. Twice. So this was the third time?
Yeah, either the second or third time.
Okay. And when you arrived, did you find that the condition of his apartment kind of bothered you?
Yes.
And could you tell us why that bothered you?
It was just disorganized. I think he was doing construction work on his front patio doors. So all of his things were kind of like piled away from that area, and it was messy.
And so you found it very disorganized, and did you suggest that you help him organize everything?
Correct, yeah.
I'd like to show you some pictures if this will stay up. When you were at this apartment, do you remember what street it was on?
No.
Do you remember the neighborhood?
Yeah.
Was he in an apartment building, or was his unit attached to a standalone home?
It was attached to a standalone home. It was like the lower level, I think.
So it's kind of like what someone might call a granny flat or a...
Sure, yeah.
Okay. So I have a series of photographs I'd like to mark.
I mean, I don't know where they're going with this, other than if his house is a mess, he was depressed, but they also said that his house was under construction. Now, having my house being under construction, it definitely does seem that your house will be a mess. My house is currently under construction and things are not where they should be, and it does drive you just a tiny bit nuts. But yeah, I don't care about his depression all that much, to be relatively, 100% honest with you guys.
What's the next one in order?
The double S, so photograph 1 through what now?
I've got one.
I have that thing cleaning ADHD, so I start, sweeping the floor, but then I'm kind of limited to the main level of my house now. So if everyone has taken, I swear to God, we have 5 brooms, but if everyone's taken them here, there, and everywhere, except for the cleaning closet where they're supposed to be, then I'm on for the mystical search for the broom, and then I find a mess here and there. And by the end of the day, I don't know where I am, but I've managed to clean up little messes everywhere. Nothing looks clean.
1, 2, 3, 4.
It happens. It happens. Oh,
9
Lord, ma'am.
photographs.
All right.
D 1 through 9.
I just want to deep condition your hair, ma'am.
Right. I use this. I have actually 16, Your Honor. So it's defense, D 1 through 16.
Double S 1 through 16.
I call that cardio and shoving everything into one room that keeps the door closed. And I threatened everyone within the inch of their life that open that door.
I'm going to show you what's marked defense SS1. Do you recognize this location?
Yes.
Is that the living room of Gareth's residence?
Yes.
That's why I call him Doogie Howser. I don't know.
Showing you it's been marked defense double S2. This is part of the living
Yes.
room.
Yes.
Was this the type of condition that you saw it in?
Correct.
All right. It's not terrible.
This is the other side of that built-in cabinetry in the living room area.
Yes.
So is this the condition you saw it in?
Yes.
That'll be a good idea for this Halloween in the murder board, though. That's a good
Great.
idea.
This is defense 4. Double S4. Is this the condition?
Yes. Yes.
All right, let's approach if you would.
The judge is like, what the hell are we looking at this crap for? You'd think my youngest is all set to go down to Mexico and see the aliens. Since Area 51 won't show us the aliens. But Mexico has them. Direct quote.
All right. So the next one will be double S5.
All right.
And the one puts the 6 photos, it's 6 additional photos.
6 additional photos and plus 16?
No, you said pick 6. So
Yeah, sure.
6.
Whatever you want. That's fine. Yeah.
Does this accurately reflect the state?
Yes.
Fry, what are you doing?
There seems to be construction materials.
Well, as long as you're chillaxing and not biting or barking at anyone. You do you, Fry. It's Friday.
Yes.
And this is 6. This is 6. This is the living room again,
Yes.
and that's an accurate representation.
Yes.
7. This is SS8. Is this accurate representation?
Yes.
9. Is this an accurate representation?
Yes.
And last one, SS10. You were in his garage when you went to get into the vehicle to be driven home?
Yes.
Is this an accurate representation of the garage?
I don't recall the garage.
Okay.
So Ms. Burstein-Lev, I'm just going to modify it. Double S is 1 through 10 as opposed to 1 through 16.
Okay, thank you.
All right. Yep. So it's 1 through 10.
Lawyer math. Well, yeah.
Did you remember telling the detectives who interviewed you after the vehicle that you were in with Gareth was stopped? Do you recall telling the detectives that his place was disgusting?
Probably, yes.
Well, prior to testifying today, in addition to speaking with the prosecution, did you get to review the audio tape of your interview with detectives?
I read the transcript.
You read a transcript? And do you recall telling the detectives that Mr. Pursehouse, or Gareth, had told you that he'd had an excruciating breakup with an ex?
Objection, hearsay?
Interesting.
Well, this witness was asked on direct about this.
Objection, hearsay.
The question was whether or not he ever mentioned an individual or a prior relationship with this individual. You can ask that.
Well, but he had told you he had a bad breakup.
Objection, hearsay.
Okay. Did he ever mention that?
Yes.
Okay, I'll allow that. Good.
So he told you he had this excruciating breakup.
Well, I'll allow the prior answer to stand and let's move on.
Okay.
A bad breakup.
And had you tried to talk to Gareth and get to know him on a deeper level and find it was difficult for him to open up to you?
I think she got to know him on some level.
Somewhat, yeah.
And you said that when you saw him on the 15th, when you went to his place on the 15th, he didn't seem as he normally was. He seemed sad and distant.
Correct.
And how could you tell he was sad and distant?
We didn't chat much, and he was kind of staring off into space, doing something on electrical on the door.
And do you recall saying to me when we spoke that you felt sorry for him and you wanted to be there when he was sad, the same way he'd been there for you when you were sad?
Yes.
Ma'am, you knew him for 2 weeks. Why are you giving him girlfriend rights? You are in a undefined relation dateship. You are not in a boyfriend-girlfriend pre-marriage thing. You are extending emotional support to someone who did not even text you on Valentine's Day, said he was busy doing stock terrorism or whatever.
I'd like to talk to you about when you
And
left.
I have to be the voice of reason.
Gareth's place. You had ridden a bike to his home, but you didn't want to have to ride it back. Is that correct?
I was going to ride it back. He offered to drive me home.
Okay.
I like riding bikes.
Okay.
It's not unusual.
Okay. So he offered to give you a ride and you accepted it
Correct.
because you had some friends that you were meeting up with later.
Correct.
And so you and Gareth walked out the back of his residence.
Yes.
And there's like a long flight of stairs that lead through the yard and that lead to the detached garage.
Yes.
And his vehicle was in the detached garage.
Yes.
And it was a red Lexus.
Yes.
And so did he open, if you recall, did he open up the garage door with him, or did you go into the garage and he went out front by himself?
I don't remember.
Okay. So then you both did get in the car.
Yes.
And he drove out of the garage.
Correct.
And as you both were driving out of the garage, what happened?
We were blocked in by several cars, and I wasn't really sure what was happening. I think they were normal looking cars. And then I think a police car showed up at some point, and then they started telling him to get out of the car.
Did they tell both of you to get out of the car?
They asked him to get out first.
And how did they ask?
Sustained.
Did you see any guns drawn?
I'll allow the answer. I think that one witness already testified that there were the guns. Did you notice any guns drawn?
I don't recall, honestly.
Was it scary for you?
Very,
I'll allow the answer to stand.
Could you repeat your answer?
very.
Did Gareth say anything to try and reassure you?
Yes.
What did he say?
He said,
Objection, hearsay.
I'll allow it.
he said, just do what they say.
And did you see Gareth get out of the car?
Yes.
And how was he able to get out of the car?
Through the passenger window or door or window, I can't remember, but and then he got face down on the ground.
And was that according to the instructions that were being yelled at him?
Yes. Yes.
And the instructions were yelled at him by officers?
Yes.
Yeah, it'll stand. All right.
I'm sorry, it will
It'll
stay.
stand. Go ahead.
And then after Gareth got out of the car, did you have to get out of the car too?
Yes.
Were you instructed to also lay down on the ground?
Sustained.
Did you lay down on the ground?
Objection.
Sustained.
Did you see Gareth taken away in handcuffs?
I don't remember. I saw him in the back of a car. I don't recall if it was in handcuffs.
This was a frightening experience for you?
Yes.
Sustained.
Well, Your Honor, she made a statement to detectives afterwards, and I think her state of mind is important.
I think, why is your state of mind important? We can talk about that sidewalk, but that's not. But she's already answered previously that it was a scary experience. I'll let that stand.
So you then went, how is it you came to talk to any detectives?
A police officer sat me down on the sidewalk. He wouldn't tell me what was happening. He said, wait for the detectives for your questions. And then a couple hours later, 2 detectives came and talked to me.
So you sat on the sidewalk for 2 hours?
I don't recall exactly how long, but it was a while, yes.
And then where were you while you spoke to the detectives?
I was in their car.
Was it still on that street where the arrest was conducted?
Douche.
No, we drove, I think, to the impound to get my bag. That was in the car, in Gareth's car.
Okay, so the officers drove you to retrieve your personal property from the car that had been impounded.
Correct.
So you went to the tow yard to do that, and you were having a conversation on the way.
Correct.
That's way too much energy for me. I'm too lazy to be a stalker.
Now, when you say you saw scratches on
Mr.
Gareth's
Mo's ex,
face, where did you see the
broke
scratches?
into his Facebook when we first started dating and was big hot mad about us dating.
I don't recall exactly. There were a couple on his neck and
That
face,
was fun.
if I remember correctly.
Do you remember what side of his face they were on?
I want to say the right side of his face.
Yeah, I need to watch.
Do you remember
that
how
with
many you saw?
guys.
Maybe 3 or 4.
Can you describe the scratches? Were they scabbed? Were they welts? Were they red? Any way?
They were red.
They were red? Can you describe how long the scratches were?
Maybe a half inch.
And you don't know how many there were?
No.
Would you say it was more than 2?
Didn't she say 3 or 4?
3 to 4?
Was that your answer?
Yes.
Okay. And all on the right side, as far as you can recall.
Yes.
And so those 3 to 4 were all either on the face or on his neck?
Yes.
Do you recall what Gareth was wearing that day?
I think he was wearing orange basketball shorts, and then he changed.
What was he wearing a t-shirt?
Yes.
A short sleeve t-shirt?
Yes.
And basketball shorts?
Yes.
And that was while you guys were organizing the apartment?
Correct.
And then he changed before he drove you home?
I don't recall when he changed, but yes, that sounds right. At some point he changed from what I saw him in.
Okay. Did Gareth tell you whether or not he'd ever fired a gun before?
I think he said he'd never fired a gun before.
And do you have experience with firearms?
Yes.
And is that something you had told Gareth about?
Yes.
And had you ever suggested to Gareth that you guys go to a firing range?
Yes.
But on this particular day, Gareth suggested that.
I believe so.
Did that surprise you?
Not particularly.
Looks like she's engaged.
Did he tell you why he wanted to go to the firing range?
I think it was in.
Did you ask him why he wanted to go to the firing range?
No.
Were you aware that Gareth's father had died recently?
Sustained.
Do you recall Gareth telling you he had a shoulder injury?
Sustained.
Did you ever notice there was a shoulder injury that Gareth had sustained prior to February 15th?
Sustained.
After Gareth,
understand.
did you see Gareth taken into custody and driven away in a police vehicle?
Yes.
I don't understand what we're getting to at this point. Like, what?
And so
Why?
you still remained at that location after Gareth was taken away.
Yes.
Did you observe his demeanor during the arrest and transportation away from this location?
I'll allow the question to be asked. Did you observe his demeanor?
Yes.
Okay.
How would you describe it?
Calm.
Thank you. Nothing further.
Any regret? All right.
All right, guys, I am going to stop it here for Sal and EU to look at later on because I'm getting close to the time where I'm going to go pick up the boys, and Mr. Friberto needs to go outside and try to walk and use the restroom again because he has had lunch and he's supposed to be an outside puppy. He's supposed to motivate me to go outside and do stuff even though I don't want to because look, just a little side note here in case I've been a little bit either more or less on top of it this week. I have been training myself to wear boots again, which does not sound like a feat in and of itself, but it is a feat in and of itself. I've been wearing exclusively Birkenstocks and transitioning back to wearing shoes with my right leg mirroring my left leg now sometimes. It has been. Oh, yes, I can also change. I am going to add that I did have the Karen Reed uh, hearing No, I don't need it scheduled later. Yes, I'm save changes. I'm good. I don't need it scheduled later. Stop it. It's yeah, it's not been an easy week, but I need to get used to it because I can't wear Birkenstocks in the winter. So it is just one of those things. So it has not been a fun or easy week, but I have Mr. Friberto to keep me motivated on fun things while I'm dealing with not so fun stuff. And then next week I am going to try water aerobics. So that'll be an interesting thing. But I will see you guys later. I don't know if I will be doing nightly newsy news tonight. It will all depend on how my leg feels, and I don't know. I will let you guys know later on, and I will thank you guys for joining me today. It's been nearly 4 hours. Yeah, her defense lawyers did a wonderful job. I am really getting irritated with the state and, their evidence. The Delphi people are having a lot of the same issues, so I'm getting very tired of these prosecutors not having the evidence ready to go for the state or for the defense to look at. It's beginning to become a pattern in some of the cases that I'm looking at, and it seems to be becoming a pattern in cases where they don't have a lot of evidence. So I am not impressed. I will see you all later. Have a great day. Please like and subscribe and share with your friends if you think they'd like it. We are always looking to grow here. We, meaning me and Fry, whenever he's on camera, and Thor whenever he's not looking at the squirrels, since the cat trees are now out in the front room. Cats have the other cat trees are up in the front room. They love it out there now. They can watch the squirrels in the big giant picture windows. Have a wonderful day, guys, and a wonderful Friday. I will see you later. Bye, guys.